Supplemental list, fresh admission, item number 1.
May I please? This is the case, my lord, the petition filed by way of public interest litigation. That is the annexure 4 is my representation pending before the opposite 2 regarding the construction of Anganwadi building.
All right, the petitioner's representation be examined by the collector.
Supplemental list, fresh admission, item number 1.
Collector Baleshwar, you have to notice the petitioner.
May I please?
Hearing.
This is the case, my lord, the petition filed by way of public interest litigation. That is the annexure
In July.
4 is my representation pending before the opposite 2 regarding the construction of Anganwadi building.
Item number 2.
All right, the petitioner's representation.
My lord, in this appeal have challenged
Supplemental list, fresh admission, item number 1.
the Lawrence
Collector Baleshwar,
single
you have to
judge
notice the petitioner.
passed on
May I please?
2021 and
This is the case, my lord, the petition filed by way of public interest litigation.
mainly on
That is the annexure
ground of
4 is my representation
lack of
pending before the opposite 2
compliance of
regarding the construction of Anganwadi building.
Item number 2.
All right, the petitioner's representation.
an application in this appeal have challenged
Supplemental list, fresh admission, item number 1.
the Lawrence under the
Collector Baleshwar,
passed on
May I please?
2021
This is the case, my lord, the petition filed by way of public interest litigation.
mainly on
That is the annexure 4 is my representation pending before the opposite 2 regarding the construction of Anganwadi building.
Item number 2.
an application in this appeal have challenged
Supplemental list, fresh admission, item number 1.
the Lawrence under the passed on 2021
This is the case, my lord, the petition filed by way of public interest litigation.
mainly on
That is the annexure 4 is my representation pending before the opposite 2 regarding the construction of Anganwadi building.
Item number 2.
now my application in this appeal have challenged
Supplemental list, fresh admission, item number 1.
the Lawrence under the passed on 2021
Yes, my lord, the petition filed by way of public interest litigation.
mainly on
That is the annexure 4 is my representation pending before the opposite 2 regarding the construction of Anganwadi building.
Item number 2.
now my application in this appeal have
Supplemental list, fresh admission, item number 1.
the Lawrence under the passed on 2021
Yes, my lord, the petition filed by way of public interest litigation.
mainly on
That is the annexure 4 is my representation pending before the regarding the construction of Anganwadi building.
Item number 2. Supplemental list, fresh admission, item number 1.
Yes, my lord, the petition filed by way of public interest litigation. Annexure 4 is my representation pending before the regarding the construction of Anganwadi building.
Yes, sir. 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 question law opens up, they are using civil arbitration. question now opens up reality to
Days after that, came saying that you have not paid salary to one of the employees. I responded that. When I responded, I said that is business payment of wages. He has not paid. It's a case of payment, delayed payment. To recover and principal employer can also do it. Days after that, one was right on the payment. Saying that what has happened, I responded to it. Thereafter came back, I responded to it. 5 page 41. That is return of commitment by radio authority saying that has to be examined. On page 41, then came annexure 7 on page 45 years. Case of payment by letter dated 11 principal employer can also do it. And after that is right. Allied concern, I prohibiting all means execution. That is return of banning by radio authority saying that only allegation or delayed payment as obtained immediately. Then came another challenge to letter dated 11 see the order and page 16 relevant prohibiting all prayer in the and so therefore we are time and again saying that then wrapping up and in the case where you are that may be grounds prayer
what you've done is banned you from participating in all Indian Railways projects.
Again, not only mirrors this, he says that all sister concerns, all allied concerns, all are prohibited. All are prohibited. That your lordship
only
will
railway
find.
PSUs. Just let's read that.
Yes, my lords may kindly see page 45.
Yeah.
Running page 45.
Right.
My lords, annexure 7.
Yes.
Your lords, Oriental Security Service was sought with memorandum of statement, imputation of misconduct, of banning a business dealing with them having committed serious misconduct as found in investigation on the aspect of deviating contractual obligations as per contract conditions, violating provisions of. That's what is violation is, as I told you, lordship. That is nothing more, nothing less, Milos. Only non-payment, that delayed payment, Milos.
That, sir. What is the effect of this?
Exactly. Yes, exactly. So paragraph 2. In reference to memorandum of statement charges, clarification of farm and the views of East Coast Railway by DCR letter so based on facts available in the clarification merits of the case, the competent authority has considered the matter and established that Oriental is fully responsible for indulging in the malpractice by way of deviating the contractual obligations as per contract conditions and violating provisional labor laws. This is generic. Nothing is specified. Your lordship may kindly see. Nothing. It has therefore been decided by the competent authority, Ministry of Railway, that business dealings with Messrs. Oriental Security Services, Saidnagar, and also with their allied sister concerns and partners should be banned on all India railways, on all Indian railways, including project organization, production units and railway PSUs, etc. under the Ministry of Railway. It's omnibus order. Everything.
No. Only for the railway PSUs and railways. What is the interim order you're seeking? That's not clear.
So interim order, I have prayed for this stay of annexure 7.
That will be the final relief, sir. That's the final relief.
But now what has happened? You will kindly see annexure 9 for a moment then. Annexure 9, Mirrors. that is annexed along with the second interrogatory application. Your Lordship will find from page Lords 68 for a moment. My Lordship, kindness. Page 61. I'm so sorry. Page 61, annexure 9. But ongoing works has now been stalled. Two LOS, my annexure 9, page 61. Further, going through the contracts executed by your firm in this department, it is observed that 2 numbers of LOS were issued after effective date of banning of business by Railway Board. Details are awarded. So, as per the banning letter, above 2 hours required are to terminate it due to false statement action taken to be terminated. They are going to terminate now. That's why we stand 5,000 laborers, my family, they're depending upon me.
No, that may be. I'm just saying the nature of the relief paid because the writ petition is still pending.
Your Lordship
And
knows.
it's already listed for final hearing. It's been listed for final hearing on 5th July.
Yes.
So what else? See,
Because now, unless your Lordship grants you protection, your Lordship can think for a moment. Supposing your Lordship doesn't pass an interim order. Because the golden principle is 3 things. Prime versus case, balance of convenience, whereas irreparable injury. Supposing your Lordship will not grant him protection, interim order. Then consequently what will happen? All ongoing projects mirrors. Only for the purpose reason that is delay payment of salary. It is not that salary not paid. Only because of delayed payment of salary which has already been paid by now. Whereas all ongoing projects stalled. I cannot work anywhere. Supposing tomorrow your Lordship comes to a finding that I will succeed.
What are you challenging here?
I am challenging Annexure 7, Milors.
No, there's
In the
end of Annexure 7 is list the matter for final hearing.
Correct.
It does not express any view on whether the prayer should be granted, not granted.
Para 9, Milors. My Lords, para 9, your Lords, may kindly see. At page, Milors, page 66. Page 66. Honorable single judge.
If you're dealing with Annexure 9, it's one thing. If you're dealing with Annexure 7, is another thing.
Correct.
You are seeking relief in relation to Annexure 7. So the judge said, if I'm going to stay Annexure 7, it's the final relief. And that's correct. That is correct. You are now referring to some Annexure 9, which we are not arguing before the learned single judge.
No, it was. Because it's a part of the interview application.
No.
It's a sequel. Well, it's a sequel. And the only basis of bringing the second interrogatory application.
There are 2 IAs, is it?
Yes, exactly. The second IA came only because of Annexure 9.
1 minute.
Your Lordship will find second interrogatory application came only because of Annexure 9.
Where is it?
Only because of that, Your Lordship is correct. It's a sequel only.
No. Prayer, just seen that second
Prayer
application.
I have seen that. I have seen.
You can't, sir. If you're finding fault with the single judge,
Your Lordship knows we will not all those things.
In an appeal, you have to say why the single judge was wrong.
Oh, yes.
But
only
here,
thing,
but here, even in your second application, you did not seek for a stay of that Annexure 9. You still was seeking a stay of
Annexure 9. If your Lordship will read, your Lordship have read, I believe, Milors. But certainly, I don't think my Lords will at all afford to approve this. Lordship, kindly see for a moment. I'm reading. Let us read together, Milors. This court entering into the hearing in IAS find both the IAS have been filed seeking staying of Annexure 7. It's all along in all writ petition that happens. At least till disposal application. It's an interim only. Reading the nature of the order at Annexure 7, this court finds the only possibility in dealing with the order at Annexure 7 will be through the final hearing of the matter. As otherwise also, if Annexure 7 is stayed at this stage, that will attend to final relief in the petition.
On that, there can be no question at all. In fact, if Annexure 7 is stayed, it will amount to final relief. There's no question of that.
Stay. Your Lordship is not granting, allowing
so what will happen if a ban order is stayed means what? You continue dealings. Then as if there is no ban order.
And your Lordship will have
that's the final relief.
My Lordship
final relief also will give you the same relief.
Correct. Root measures, your Lordship, what is the genesis? Genesis, non-payment, delayed payment.
Whatever. We are only on the nature of the relief now.
That's how, may I pray, Milors? Your Lordship may permit me liberty to move Annexure 9 so that both can be considered at least.
And you want to withdraw, you withdraw, sir. Counsel for the learned senior counsel for the appellant seeks leave to withdraw present appeal with liberty to file a separate application vis-a-vis the letter dated
Whereas Annexure 9 is dated
20th
Annexure 9
April
is-
2023.
Yes,
20th
yes.
April 2023,
yes, 61.
written to the appellant by the East Coast Railway.
Correct. Senior Divisional Mechanical Engineer.
Yeah. Full stop. Disposed of as withdrawn with liberty as prayed for.
The opposite party.
Item number 4. Well, wait, please, Your Lordship. Would your Lordships kindly turn to page 190 minutes? 190. This is an order passed under section 26 of the NGT Act, my lord, which is the nature of contempt for non-demarcation of notifying of elephant corridor.
We are already seized of that matter.
Your Lordships are seized of the matter. I'm grateful, my lords. Page 192 at page 195, all the timelines.
But have you brought this to the notice of the
Yes.
entity?
If your Lordship sees, kindly see, my lord, page 177. Just the previous order, my lords. And if my lords are graciously pleased to turn to 178. My lordships have it.
Yes.
It is also pointed out that the PIL is also pending in the Honorable High Court of Orissa bearing number so and so.
Hmm.
So let his proceedings await till your lordships take a decision in the matter.
You see, Mr. Ashok Parjad, the Advocate General, appearing for the petitioner, State of Orissa, draws attention to an order dated 14th March 2023, passed by the National Green Tribunal, Eastern Zone Bench, Kolkata, which notes in paragraph 4 of that order that this court was seized of WPC bracket PIL number 14706 of 2022 bracket Gita Roach versus State of Orissa on the same issue of notification of an elephant corridor in the state of Orissa. Paragraph. However, the subsequent order dated
6th of April.
6th April 2023 an ultimatum has been given by the NGT to the state to notify the elephant corridor within a month thereafter and open quotation, no more, unquote, stating that open quotation, otherwise the concerned authorities shall be liable under section 26 of the National Green Tribunal Act, full stop, unquote. Paragraph. The next date of hearing in WPC civil PIL number
14706.
is coming on the very same date that the NGTs listed the matter, that is 9th May 2023. Stop. This court is in fact passed a series of orders in the said PIL, all of which were brought to the notice of,
Yes.
all of which Mr. Parija states were brought to the notice of the NGT. Stop. It is not desirable, therefore, for there should be parallel proceedings, both in the NGT and this court, on the same issue. Full stop. That is the matter. The further proceedings in execution application number 3 of 2022 /EZ in OA number 129 of 2016 oblique EZ shall remain stayed till the next date. List this along with on 9. Meanwhile, just say notice be served on the respondent. That's the
Deep blue line.
The proponent one, my lord.
respondent number 1. Sorry. Respondent number 1, that's the
Where the proponent
party accepts notice on behalf of pro forma. Respondent number 2. Okay.
both the case, Mr. Kashyap name will reflect. Please appearing with me. Satya Sundar Kashyap is appearing with you. Both the case. 3 and 4.
I see.
Okay.
Item number 5. Item number 5.
None appears dismissed.
Item number 6.
None appears dismissed.
Item number 7.
None appears dismissed.
Item number 8.
Here, my lord, there is a noting that this should be WPC PIL, but with due respect, that the grievances of the petitioners are the villagers and the grievances about encroachment of the communal lands of related to that village. Therefore, they are directly affected. May not be PIL, my lord. Only grievance is that after much
You made a representation.
my lord, in the meantime, they have initiated the OPLE case. And that is in May 2022. Till that, no further action has been taken. My simple grievance is that let that be in accordance with law, that may be taken.
Where is the case number?
My lord, that is from page 45, that is Annexure 8 series, from 45 to 103, my lord. Individual cases, my lord.
May 22.
My lord, 24, 5, 22.
Mr. Mohanty is here. Mr. Mohanty, this
Yes,
just
sir.
says that OPLE cases should be expedited.
There are OPLE cases pending before the Tahsildar.
So should we simply say that those should be expedited, or
But there are so many OPLE cases, multiple.
how many OPLE cases are there?
61.
61.
Sorry, my lord, say 45.
Even then. It'll take time, sir. We can't simply fix a timetable.
Let it take time, but no further action is taken after May 22. After issuance of notice, no further action has been taken.
The grievance of the present petitioners is that although cases under the OPLE Act have been instituted against opposite parties,
5 to 61.
5 to 61, on 24th May 2022, no further action has been taken in those OPLE cases after that date. Most of the said cases are admittedly pending before the Tahsildar. Go. Stop. Since the prayer is only for expediting those proceedings, the court considers it appropriate to direct that the petitioners can approach the Tahsildar Gop with a request for expediting those proceedings. And the Tahsildar, and if such a request is made to the Tahsildar not later than 15th May 2023, the Tahsildar will act on such request and prepare a schedule of hearing of the pending OPLE cases and communicate that schedule to the petitioners within 4 weeks thereafter. he will simultaneously communicate the schedule also to the persons against whom the OPL cases are pending. No further directions are called for. The petition is dismissed.
Item number 9.
May I please, my lord? This is a public interest litigation, my lord. Earlier, may kindly see the annexure 5, my lord, page 37, 38. Earlier, an order was passed by this honorable court directing the collector Baleswar and others to evict to take the appropriate action against the encroachers who have encroached.
Just come to page 1 and 2, sir, the cost title.
Yes, my lord.
Which of the opposite parties are the encroachers? Which of the opposite parties is the encroacher?
Opposite parties are the opposite parties, those who have encroached under annexure 2, my lord.
No. Cost titles. Which of they have to be made opposite parties, no? Encroachers have to be made opposite parties.
Yes, my lord.
Which of the opposite parties are encroachers?
Encroachers are not mentioned here.
Why not? Why not?
Because the under here, my lord, that is 189 encroachers are
Whatever,
there.
sir. No shortcuts.
But
No encroacher should be, no order should be passed against.
But the action earlier order has not, earlier order of this honorable court has not been implemented, my lord.
That's not an excuse, sir. If you want an order against an encroacher, you have to make that encroacher a party.
So the encroachers are day by day increasing.
Correct.
So government land may kindly be protected.
For any such order to be passed, sir, you'll have to make the people who are likely to be adversely affected
that is
as parties. That's
that action has been taken.
That's a very
Some
basic
action has been taken by the opposite party number 4 to 7, my lord. Notice has been issued. Your lordship may kindly see annexure.
All right, sir.
Annexure 2 series, 3 series and 4 series, my lord. The letter has
Sir,
been issued by the Tahsildar.
You're not inclined, you don't want to implead them. You're not inclined to implead the encroachers as parties, correct?
Yes.
You said, despite pointing out to counsel for the petitioners that the reliefs prayed for by him against alleged single courts encroachers cannot be granted unless such alleged encroachers have been made party to the present petition. He declines to make them parties. Full stop. The court is therefore not able to grant the relief prayed for. The petition is dismissed.
Lord, government has initiated some proceeding against those people, encroachers, but that may be initiated, that may be implemented.
Item 10.
Here the petitioners are challenging the illegal order passed by the Tahsildar for construction of health subcenter building under Usuma Gram Panchayat over Khata number 1217, which was reserved for the construction of school. And have a glance on annexure 4C, my lord, page 17, my lord. Plot number 2627, which is reserved for construction of school, my lord.
There are defects pointed out. No? Look at annexure 1, how dark it is.
Yes, my lord.
Are you able to read annexure 1? Are you able to read it, sir?
Yes, ma'am.
You're able to read. You have exceptionally good eyesight, sir. Just show me that. Just show it to me. You're able to read.
My lord, is a photocopy for which there is a shadow occurs, for which it could not be visible, my lord.
Even for you, it's a problem, no, sir?
No, sir.
Actually, we are old, much older than you.
Sorry, my lord.
Sorry, you cannot able to read all that. Even you have a problem. You also have a problem, no?
I'll file a press.
Very good, very good. Defects list on 31st July. Defects be cured. So this is the only High Court. Anything can be filed, it will be listed. Because the rule is without a vakalatnama, without an affidavit, without court fee, without clear copies, anything, matter has to be listed before the court. It will only be said listed with defect. If the registry says we can't list with all these defects, bar will protest. I've been told as Chief Justice, sir, you can't do anything about it. You will have to just go along. Without wakalatnama, without affidavit, without court fee, without clean annexures, matter will still be listed. No other high court this luxury is there, sir. I can confidently tell you. In no high court, without a wakalatnama, without an affidavit, matters getting listed is unheard of. Unheard of. Anyway. All right. You're a young member of the bar. See what has happened because you are careless about this. Now it is now postponed till you cure the defect. Not able to get the relief, correct?
Yes, ma'am. Sorry.
All right.
Maybe
Item number 11.
remove it.
May I please your lordship? My lord, here the PIL,
Yes.
the instance of one of the villagers
Yes.
who had submitted his objection to the public notice at Annexure 2, my lord.
Yes.
The collector as well as the commissioner, they have recommended the proposal of OP number 5 for ratification.
Yeah.
So meticulously they have not dealt with their objections because lordship knows in Bhubaneswar and periphery is a temple city, my lord. So many objections, so many restrictions, it comes under the rule 26, my lord. So only my prayer, let government give an opportunity to hear the objections.
That objection has already been dealt with.
Your lordship on several cases directed government because they have extended the period lordship knows till June, 31st June.
Not repeatedly.
So there,
Once it
my
is-
lord has directed in several cases. In my case,
Several
at least
cases
17 to
where
18
objection is
cases.
Not dealt with.
These similar circumstances, your lordship
Where
has
the objection has not been dealt with.
Yes.
not with you properly, my lord, because so many
Not for properly. Where it is
so
not been
many
dealt with.
lordship may see the
The hearing opportunity now we're not granting, sir.
my lord, lordship
Open
may
a
see,
Pandora's box.
let government consider, my lord.
No, how do you know they've not considered?
Lordship may see the recommendation letter that on Annex 3, page 14. Lordship may kindly come to the relevant portion that page 15, the middle para. They have dealt with the objection of others, my lord.
No, the excise commissioner has to still forward it. The government has
Well,
to take a
lordship-
decision.
Lordship knows what commissioner does, my lord, only to transmit the file.
We don't know.
No.
Yes, my lord.
The recent
And-
order he has.
My experience, my lord.
Let it happen. The present petition appears to be premature since the government is yet to take a decision. There is no need to presume that the objections filed by the petitioner will not be considered before the government takes a decision. Consequently, the court is not inclined to interfere at this stage. The petition is disposed of.
Lordship, at least the state government directed re-inquiry into the matter.
No. Yes.
Item 12.
Then I may be permitted to withdraw, my lord. But because otherwise I will be misunderstood.
Why should you misunderstood? Nothing. It's all right. Let that order. Yes.
Item 12.
Permitted to withdraw, my lord.
No. Sorry. It's over now. Yes.
Yes, my lord. It's a PIL, public demanding for availability of drinking water. Though till today they are using river water. Annexure 1, page
Or
12 is pending
Petitioner's
before.
representation, bracket annexure 1 shall be considered by the collector. Baripada. Sorry, Mayurbansh. And after notice to the petitioner giving a hearing, an appropriate order shall be passed. Reasoned order shall be passed not later than 15 July and be provided to the petitioner within a week thereafter. All right.
Item number 13.
Your lordships have issued notice in this matter, but your lordships had also directed that 25 lakhs is to be deposited. Unfortunately, his father fell ill, my lords, and was in the ICU for about 2 months, my lords. So we are praying for another 1 month's time to deposit this amount. Thereafter, your lordships may.
No.
I have filed an IA to only to that effect, my lords.
IA was filed when, sir? Is all right. This IA you say 405/2023. it is stated that the appellant was in some genuine difficulty and could not comply with the conditional order passed by this court on 9 January 2023. Paragraph B. Time for the appellant to deposit with the respondent Orissa Forest Development Corporation 50% the amount demanded is extended up to 31st May 2023 and no further.
Deeply obliged.
The application is disposed of. The main matter you say is subject to the appellant complying with the above direction. Notice be issued, returnable.
OPDC has already. OFDC has already appeared. my lords.
Oh, I see. The main matter you say so and so appears in behalf of OFDC. There's only one respondent, right?
Yes. my lords.
Two, okay. On both, on behalf of respondents.
Both.
No, 3 and 4 are the state, I think.
Yes.
And 2.
Tahsildar and the
Yeah.
sub-collector.
Mr. Kuntia accepts notice on behalf of Mr. Kuntia, who will accept notice for the Tahsildar and or Mr. Manti? Tahsildar Rajgangpur. Okay, Mr. D.K. Manti accepts notice for 3 and 4.
Yes.
Copies being served
Miscast
on
copy. Miscast copy. I got a copy. Yes.
in IA number 311 of 2020, this is subject to compliance with the above direction regarding deposit. The interim order will continue till the next date. List on 29th August.
Deeply obliged.
Item number 14. Item 14.
In item 14, my lord, notice has already issued. So it's a Sattapada matter, it can be fixed to 8 May.
8 or
14, 15, 16, 17, all are Satta, and 18.
18. All right.
8,
Item number 19.
19, my lord, work charge, that is 14th September.
14th September.
Item number 20.
In 19, you say fresh notice returnable.
Yes, my lord, that fresh because it has been returned. Fresh notice too.
Yeah, returnable 14th September. Interim order to continue. Right.
Item number 20.
20. Last occasion, your lordships directed the
20, my lord.
counsel for the
Require some time to file respond, my lord. Counter.
So writ appeal, sir.
Last occasion, your lordship directed. Instruction also not with me.
All right. A request is made on behalf of the respondents. No, at the request of the respondents. Time to file counter affidavit is extended by 6 weeks from today. Rejoined for the next day. List on 5th September.
Item number 21. Item 21.
None appears dismissed.
Item number 22.
Not because of some medical emergency, my lord, can I seek for an adjournment in the matter, my lord?
Which matter, sir?
Not 22, my lord.
22.
Yes. Well, medical emergency in the family, my lord, for which?
Mr. S.S. Das, Learned Counsel appearing for the respondents.
No, appellant.
Appellant.
Yes.
Oh, appellants is stated to be in some personal difficulty today. List on. Twenty-9th August.
Item number 23.
promotion during pendency of vigilance case. 11th May,
11th.
24.
24, my lord, 11th of May, my lord, vigilance sent.
I'm appealing for the respondent, my lord.
All right. Put his name for the respondent.
Item number 25.
May I please your lordship, not appearing through VC, but I am for the appellant. The identical matter between the same parties, not only the vehicles were different. That was in the writ appeal number 1703 of 2022. Lordship issued a notice and also passed the order staying the order of the land single judge. This is the case where the land single judge.
When is it coming up, sir?
It is coming on 17 July 2023.
All right. List along with WA number.
Writ appeal number 1703 of
Yeah, on 17 July. It's a notice returnable and then interim order. There shall be a stay of impure.
obligation.
Defects be cured in the meanwhile.
My lord. 26, my lord.
Item 26.
In this case, my lord, but the impugn order, my lord, the contractual, he was on a contractual basis, my lord, the respondent he was terminated from service, my lord. The learned single judge directed that since the rule has not been followed and no opportunity of for him to give show cause notice was issued, my lord, therefore his termination was set aside and he was directed to be reinstated. Our ground of challenge is, my lord, that that rule is not applicable to him because he was on a contractual basis. And an agreement. He was a junior engineer, which is a Group B post. So the contractual appointment rules of 2013 is applicable for Group C and Group D post. He is a Group B post. That's one of them. The Lordship sees, my lord, we have also taken a ground, my lord. Since he failed to discharge his duty diligently, my lord, and show cause notice was issued, and he filed his show cause. Thereafter, he has been terminated from service. The learned single judge proceeded as if the principle of natural justice has not been followed, my lord.
May the first my submission that the respondent is a Group C employee. Since he is a junior engineer, he is a Group C employee. Kindly say the honorable single judge has quoted the provision in paragraph C, my lord. Non-conforming allowed the continue Odisha Group C and Group contractual appointment rule 2000 in the contractual appointment to rule 2003 as provided OCS CCA rule is applicable to the employee but those who have got appointment under contractual appointment rule 2013. They have not followed the provisions made under CCA rule directly issue notice for show cause. Kindly this is the honorable single judge operative person order paragraph 10, my lord. Since prior to passing the impugn order, the said provision has not been complied with. This court, while quashing the impugn order dated or such and such under unacceptable OP1 direct.
Yeah, you've been given liberty to.
Liberty, my lord. They have given the liberty to.
Liberty has been given.
You see, it is seen from the impugned order that Rule 9(6) of the Odisha Group C and Group D posts contractual appointment rules 2013 incorporates by reference the provisions of the OCS CCA rules 1962 even to contractual employees like the respondent. Stop. Admittedly, said OCS CCA rules 1962, the procedure under the OCS CCA rules 1962 was not followed prior to terminating the services of the respondent in the present case. Paragraph. Having heard learned counsel for the parties, the court is of the view that the learned single judge was right in quashing the termination order for non-compliance with the provisions of the OCS CCA rules 1962 and in giving liberty to the appellate to now proceed in accordance with those rules if it seeks to take action against the respondent. No interference is called for. The appeal is dismissed.
Item number 27.
Your state is the appellant.
I am for the respondent number 1.
I will serve copy on that.
No, my lord. He may argue, my lord.
Yes.
No, what I submit, my lords. I will serve copy another.
No, my lord. He will argue. My lord, my prayer is before your lordship may kindly hear this matter today, my lord.
Wait.
What wrong the Lord and single judge has committed, my lord, let them point out.
I will
I have, my
prepare a
lord.
date chart and short note, let it come.
My lord, here the issue has already been ended in another writ application. It was carried in appeal. It was confirmed. Now, my lord, they have filed an application after 22 years. After the confirmation made by this honorable court before the revisional court, my lord, under section 37, and the commissioner will seek an appeal against the order of this honorable court, my lord. That's why, my lord, this honorable court has quashed the proceeding. In 2001, my lord, I have approached this honorable court in filing a writ application, which was disposed of in 2021, 2019, my lord, where, my lord, the order of the consolidation officer have been confirmed. Against that, writ appeal was carried on. Writ appeal was dismissed. Thereafter, my lord, after the original order, they have challenged under section 37 after 22 years, when this order was confirmed by this honorable court. And the commissioner will sit an appeal against the order of this honorable court, my lord. That is the issue in the order, my lord. Your lordship will kindly see the, I am giving, my lord, what they have made prayer in the revision, my lord.
Lord.
Your lordship will kindly see, and that is a small piece of land in a village, and the age of the respondent number 1, your lordship will kindly see. He fought the dispute for 2 decades. And your lordship will kindly see in the revision petition what they have prayed. And the land is, my lord, only 20 decimal of land.
Where was the occasion to again file revision case 49 of 2021?
Yes, that is what
that is the
what
case,
happened, my lord. Today morning I got this brief. It is her brief, so she knows everything. So I have to brief.
No, my lord, Mr. Mahant is too competent, my lord.
No, but not to that extent competent that in court I can see, and today
my lord,
the brief.
My lord, I have given that revision, my lord. They have filed that revision to set aside the order in 2021. That is 23/3/99.
Today you are fully prepared. He is underprepared.
No, I got the file today morning itself. It is a first date of admission. First date.
All right. You give it to us the next day. Mr. Monthi states that he requires some time to get ready with the matter, as it was entrusted to him only today. As the brief was entrusted to him only today. He undertakes to file a date chart before the next date. List on opening day, 22nd.
2 days after the opening.
All right, 26th.
26th.
26th June. All right.
Well, there is nothing in this writ appeal, my lord.
That's all right. All right. Okay.
Item number 28. At 28 May, 8th May.
Sarita.
Item 29. May I please? Let's not turn to page 15, Annex 1 is the input order.
Yes.
There was a contractual employee. His services were terminated. The Honorable Singular just held that he is entitled to be protected under Rule 15 of OCA-CC rules. That you know that CC rule is not applicable to the contractual employees. And on the basis of that direction, that termination order was passed, and Honorable Singular had directed for regularization of his service. That Rule 3 of OCA-CC rule says application, these rules apply to all government servants except persons in casual employments. Those who are in regular service, CC rule is applicable only to those. And that a show cause was also issued to him because he was absconded, that could not be served upon him. And
No, why will 9(6) not apply? He's a contractual employee, right?
He's a contractual employee.
Ah,
So that CC rule is not applicable to him.
no, 9(6).
9(6).
Rule 9, we just dealt with that in the other case.
Your Lordship said that contractual appointment rules. Now, your Lordship is saying that contractual appointment rules 2013. So he was appointed in the year 2012. He is not covered under the 2013 rule.
All right. You say counsel for the appellant states that the respondent was appointed in 2012.
Yes, ma'am.
On 8 July 2012. And therefore, no. How are you? 2013 rules not apply to?
He was appointed on 35 2012. 5 2013 rule is not applicable. 2013 rule is applicable to those who are appointed under contractual rules 2013. That rule came into force on 13/11/2012. 13. This man was
12, whereas the it is hereby set aside and the expedition civil 27874 of 2021 is restored to the file of the learned single judge in the roster bench, where it will be listed for hearing on 31st August 2023. The appellant state will file its parawise reply to the aforementioned petition on or before 21st August 2023. And the respondent petitioner will file a rejoinder thereto, if any, on or before 31st August 2023. Neither party will be granted any further time for the above purposes. Stop. The court clarifies it is not expressed anything in the matter. The learned single judge is requested to proceed with the hearing of the writ petition and endeavor to dispose it off as expeditious as possible.
Item number 33.
May I please, Your Lordship? Yeah, my lord, a department proceeding was initiated against the respondent, my lord, which ended in a punishment, my lord. The punishment was imposed, my lord, permanently withdrawing 50% of pension and gratuity as per the rules, my lord. That order was challenged in appeal. Appeal was rejected. The respondent filed an OA saying that that order may be modified and he may be released with the gratuity, which is under challenge, my lord. During the pendency of that this application, the OA, my lord, another OA was passed wherein the my lord, the order of termination was challenged by the respondent. That was allowed. The state preferred a writ application before this honorable court. This honorable court disposed of the writ application, saying that the respondent is aged man about 80 years. They declined to interfere, my lord. That was challenged before the honorable apex court by the state. That notice has been issued and contempt proceeding has been stayed, my lord. That SLP is pending now. In the meanwhile, this writ application, this OA which was filed by the respondent seeking modification of that with order of permanent withheld of pension, my lord, that has been allowed by the learned single judge, saying that you pay along with interest. When the order of dismissal is under challenge before the honorable apex court.
All right, notice returnable. 5th September, there shall be stay of the impugn order.
Item number 34.
34 is work charge reply, my lord, 14th of September.
Right.
35.
35 is rehabilitation appointment, 30th of August.
Item number 36.
My lord, 36. And for the appellant. And that is, the petitioner is an old landless person and his limitation petition dismissed by the learned single judge on dated 15/7/22. But due to old age and illness, severe blood pressure, he could not attend the contacted with his advocate till 28/12/22. After that, he filed the application for certified copy on 29/12/22 and received the copy on 21/3/23. Then it is a delayed, my lord. For filing of WA, it is a delayed about 2 months and 15 days. Deducting the statutory period and certified copy, it is only delay for 2 months, 15 days, my lord. That delay may be condoned.
Delays, how you filed a writ petition 2022 challenging an order of 2000.
My lord.
How do you explain those 22 years?
22 years, my lord, that father of the present petitioner was conducting the case before the lower court consultation commissioner in the year 82. My lord, that father of the petitioner died in the meantime for a piece of land 2 decimil where he is residing. It is occupancy right. My lord, his father died during pendency of this consultation case, and his conducting advocate also died. That after disposal, the petitioner, when the government came to demolish the house for eviction, he came to know, present petitioner came to know about the result. Then file in certified copy, apply for certified copy of the consultation commissioner, and file to protect his.
It doesn't explain 22 years delay, sir.
Petitioner is a son of the ancestor. His ancestor was conducting the case.
Maybe, sir. Still,
he died.
When did the ancestor die?
Ancestor died during pendency of the consultation revision case before the consultation Bhubaneswar in the year, and also advocate also he died. He was.
Tell us the dates, sir. Tell us the dates.
But in para 6, rejection of claim petition, he handed over the brief to advocate Dinabandhu Das Puri, who filed this revision case before consultation commission of para 6. Being illiterate person, Harijan dark about the result of the commissioner till date. The meantime, petitioner received a notice from Satyavadi Tahsil for encroachment case. Para 7 of the writ appeal petition, after receiving the notice of the house, advocate Dinabandhu Das came to know that he died in the year 2009 and collected the file.
1 minute. When did he die, sir?
died in the year 19.
No. When did the father die? You said the father has died.
Father also died, and the father was.
When did the father die, sir? Which is the date?
I'm telling, my lord. In consultation order, it reveals also Abhiram Behera is the present petitioner, but his father Raghunath Behera he had filed the case. He died he was substituted subsequently. His father Ramo Behera had filed the case. That is I have collected the order sheet from the court. I will clarify. Please, my lord, give me a 2 days time. I will explain everything. That father
Counsel
died.
for the appellant needs some more time to prepare a detailed date chart, specifically indicating the date of death of the appellant's father and what steps were taken thereafter by the appellant to pursue the matter. At his request, list on. June 26.
My lord, obliged, ma'am.
Item number 37.
37 DLR 25th September.
Item number 38.
30. One person.
Passover.
One person.
Item 39.
39 was job contract 14th September.
Item 40.
40 mal satta parida. 8th May.
Item 41.
There is job contract 14th September.
Item 42. 42, sir.
May I please, Judge? Lord, there are 37 days delay in filing the appeal.
That's okay. Come to the merits.
Yes, ma'am. Lord, the impugned order is at Annexure 14, passed by the Lord Single Judge, that wrongly applying the ratio in the DS Nakara case, Lord, the Lord Single Judge has said that since you have extended the benefit to 5 other employees who have retired, the same benefit should be granted to the respondent. Lord. Though the respondent case is, Lord, entirely in a different footing. And what happened in this case, Lord, the government in 2000 has instructed the institution that you should, granting the terminal benefit, either the employee should give their option to come over the CPF cum gratuity scheme or this pension cum gratuity scheme. Lord. And your Lordship can see Annexure 2. That accordingly, the petitioner opted for Annexure 2 at page 22. All the regular employees of the institute are therefore required to exercise their option for accepting their CPF cum gratuity or pension cum gratuity in the prescribed form within a period of 6 months. That is the option was given. And the respondent gave his option, your Lordship can see page 23. That he opted for contributory provident fund scheme at page 23. That his terminal benefit will be granted under the CPF scheme. Then, Lord, these 5 employees in whose relying upon whose case the Lord Single Judge has granted the benefit to the petitioner, to the respondent, your Lordship can see. They have given the option for the pension scheme in 2004.
Whereas he did not give.
Milord?
Whereas this respondent did not give.
Respondent did not give, Milord.
All right. You say counsel for the appellant points out that although the 5 other ex-employees who were junior to the respondent specifically exercised an option to be governed by the pension scheme, the respondent herein did not.
Yes, my lord.
and therefore stood on a different footing. You say notice returnable.
And he had got the entire retirement benefit. My lord.
Further, he
Under
had
that
already
scheme.
received the entire retirement benefits upon his retirement. You say notice returnable. 11th September.
That I have
Shall be
paid
stay
for
of the
stay of-
impugned order till next date.
At an 43.
May I please, Your Lordship? There is a delay in filing the appeal, Your Lordship, 5 months, 21 days, Your Lordship.
What's the matter about?
The matter relates about recruitment to the post of dentist, Your Lordship. The order, Your Lordship, impugned order passed by the Honorable Single Judge, page 52, Your Lordship. Without going to the merit of the case, Your Lordship, this the Honorable Single Judge was pleased to dispose of the writ application, containing that in the affliction of time the writ petition becomes infectious. But in fact, the interim order was there, Your Lordship. The writ application is survived, Your Lordship, but the Single Judge could not decide it on merit, Your Lordship. The fact involves, Your Lordship, if a Lordship will turn to Annexure 4, Your Lordship, page 39, the issue, Your Lordship, Annexure 4 in the advertise number 12 of 2017 and 18, this is an recruitment to the post of medical officer, assistant surgeon, Your Lordship, where Your Lordship will found in page 39, Your Lordship, the condition imposed in clause 8. Other eligibility conditions, Your Lordship, where in 8.3 of the condition, Your Lordship.
What was the interim order in your favor in the writ petition?
My lords, of the
What was the interim order, sir?
Interim order was, Your Lordship, the interim prayer of respondent accepted, directed the authority to accept my application and to participate in the selection proceeding, Your Lordship.
Then
And
what
not to
happened?
not to publish the final order till disposal of the OA. That was there, Your Lordship. In OA, Your Lordship.
Which year was this, sir? Which year was this passed?
2017, Your Lordship.
Where is that order?
Order the page in para 4 of the page 7 of the appeal, Your Lordship, I have mentioned that is an original record, Your Lordship. The in OA while admitting an issue notice the interim order was passed, Your Lordship. In para 4 of the appeal, Your Lordship, at page 7, I have reflected the order, Your Lordship.
No, where is the order? In para 4, you simply say that while issuing notice, when on what date was that done?
The exact date, Your Lordship, the original order is LCR with the Lordship, Your Lordship.
No, that LCR, it's not there. That's the whole problem. In that LCR, no such interim order is there.
WPC, yes, Your Lordship. In OA original application, while the tribunal was passed the order, Your Lordship.
I see. All right.
My lord.
All right, Councillor, the appellant points out that. Let it go back, sir.
Yes.
Councillor, the appellant points out that in the OA number 931, bracket C of 2018, an interim order was passed by the Odisha Administrative Tribunal, bracket OAT, on 13th April 2018, permitting the OPSC to accept the appellant's application for the post of dental surgeon provisionally and to allow her to face the interview, but only that the result would not be published without leave of the tribunal. Paragraph. Thereafter, the matter stood transferred to this court upon abolition of the OAT and was registered as WPC bracket OAC 931 of 2018. Full stop. The impugned order dated 14 September 2022 of the learned single judge simply notes that, open quotation, by efflux of time, the writ petition has become infructuous, unquote. Whereas the above interim order was passed precisely for the purpose of not rendering the petition infructuous. Paragraph. For the aforementioned reasons, the impugned order dated 14 September 2022 is hereby set aside, and WPC bracket OAC number 931 of 2018 is restored to the file of the learned single judge in the roster bench, where it will be listed for hearing on 25th July 2023. No reply was filed, I think. It will be open to the respondents here, if they so choose, to file a reply to the said Parav's reply to the said writ petition on or before 26th June 2023. Sorry, 17 July 2023. The appellant writ petitioner will file a rejoinder thereto, if any, on or before 25th July. No further time will be granted to either party for that purpose. The court is the interim order referred to above will continue during the pendency of the writ petition. The learned single judge is requested to proceed with the hearing of the writ petition on merits and dispose it of as expeditiously as possible. The writ appeal is disposed of in the above terms.
Item 44.
Item 44 and 45, Mr. On behalf of Mr. Samal, my lord, he's on his legs, my lord. He requested to produce a copy of a lordship's order, my lord. Similar order has been passed.
No, my lord, similar order by playing fraud.
Since this
he
issue
obtained
was
the order.
pending before the larger bench, before the Honorable Apex Court.
Yes, my lord,
The
that is
lordship
true.
has been pleased to fix a date, my lord.
So far as the
4th
creation of the
September
post,
2023.
so far as the creation of the post as directed by your lordship
And
was
protection
stayed
is
by
also
Honorable
given to
Apex
the
Court.
respondents.
But here, my lord, clear 8 vacancies was there, annexure 8 of the writ application. Of the connected writ application, which is there with your lordship.
This plea was taken on the last occasion, for which also.
No, my lord, this is the first time. This is not the last occasion. Your lordship may please grant to have an annexure 11 page 56 of the connected writ petition 23012. Clear vacancies of the junior assistant is there. The judgment of the Supreme Court is not applicable to this. Page 56 as well as page 27. By misleading this fact, they are attempting to get the interim order. Because your lordship, when your lordship stayed in another identical matter, when your lordship stayed, yesterday night I have reviewed the proceeding of this honorable court. Your lordship specifically asked the question whether this is covered under part 1 of the Supreme Court order or part 2. This observation by your lordship was there. I heard yesterday night. And the appellant misled. No, this is the under part 1. But here, we are working as junior assistant, clear vacancies are there. But so far the other case which they are showing, this is working as the data entry operator for which no clear vacancies there, contractual posts are there.
All right. You say, counsel appearing for the respondent number 1 on advance notice points out that the case of the present case of the respondent number 1 would not stand covered by the first part of the order dated 10th February 2023, passed by the Supreme Court of India and SLP Civil 24226 of 2022. Stop. He states that there is a clear vacancy available in the post of
Junior
assistant. There were 6 clear vacancies in the post, in the clear vacancies in the 6 posts of junior assistant, against which the respondent number 1 is working. Paragraph. Counsel with the appellant needs time for instructions. List on 23rd June. Same order in both matters.
Yes, and that is not covered by this case. This is totally different. This is totally different. There, they have by misleading this honorable court, thereby by playing fraud with this honorable court. They
No, sir, there are two matters today. I'm just asking whether
Both the matters.
both matters.
Yes,
All right.
44 and 45. Item 46.
46 is about 11th of May, vigilance promotion matter.
All right. 11th May.
Item 47.
47 matter is data entry operator covered by lordship's judgment.
Patidaba on part.
Yes, ma'am.
Shraddha Das, circular. In view of the judgment of this court, so
Item 40,
the appeal is dismissed.
48.
49, Sartapada 8th May.
48?
49 May. 48, 49.
Both 48 and 49.
May.
Item number 50.
50 matter job contract 14th of September. Ma'am.
14 September.
Item 51.
This is a regularization matter 25th of September.
Item 52.
Rehabilitation 30th August.
Item number 53.
53 also same matter.
Item number 54.
May I please, Your Lordship? My Lord, there is delay of 43 days, my Lord, in filing the.
All right. Tell us what matters.
My Lord, the appellant, who is a widow, my Lord, and issueless old widow, my Lord, before Your Lordship, the appellant assents the order of the Honorable Single Judge by the Annexer 1, my Lord. Annexure 1, the operating part of the order is, my Lord, page 15, para 3. Considering that there is already long occupation of the quarters involved by the petitioner after retirement, this court directs the petitioner to vacate, my Lord. There, my Lord, the sole contention of the appellant is that the order has been passed against the circular of the government, my Lord, Annexure 4 series, running page 49. Government of Orissa Housing and Urban Development Department issued the resolution dated, my Lord, 24th June 1987, para 2, my Lord. Considering various aspects, Government of India, the Ministry of Works and Housing, in their letter dated.
Sorry, which page you said?
Page 49, my Lord.
1 minute.
Annexure? Annexure 4 series to the writ petition, madam. I have annexed the entire copy of the writ petition along with all annexures. Annexure 1 series, that is running page 49.
What does it say?
Para 2, my Lord. Considering the various aspects, Government of India in the Ministry of Works and Housing in their letter so and so, letter 9 to 78, have directed the state government to sell these tenements to those occupations of the same, subject to certain conditions. Further instructions were issued by the Government of India in their letter number.
How is this applicable to you?
My Lord.
How is this applicable to you, sir?
My Lord, the petitioner is in the occupation of their quarter.
In what capacity is the question, sir? You are an employee.
My Lord,
this is an quarters of the BMC?
No, my Lord. The BMC is not the honor of the.
Maybe the government is, but you are permitted to occupy it because you are an employee of BMC.
No, my Lord. The quarters are constructed under a scheme that is called, my Lord, slum clearance scheme, my Lord.
No, you were
development of the.
You were given these quarters only because you were employed in BMC.
The government has the quarters are constructed under the slum clearance scheme, my Lord. And by virtue, considering the Annexure 4, the self-same Honorable Single Judge has passed similar order to the against the similar situated persons, my Lord. Page, kindly see page, my Lord, running page 82. My Lord, I would like to place the order person, my Lord, page 81, third para. During course of argument, Learned Counsel for the petitioners brought to the notice of this court the document as at Annexure 4 and contents therein referred to the direction of the Ministry of Housing and Urban Development Department.
in its letter dated 9/2/1978, directing settlement of tenements in favor of the occupants. Learned Counsel for the petitioners prayed this court to give a direction to the Bhubaneswar Municipal Corporation to forthwith act on the resolution of the Government of Odisha in a Housing and Urban Development Department dated 24 June 1987, which I have referred already, my lord. Then, my lord, ordering person, as at page 82. In the circumstances, the petitioners get the full support, my lord, last para, page 82. In the circumstances, the petitioners get the full support of the documents at Annexure 4 of the writ petition. This court dispose of the writ petition directing the Bhubaneswar Municipal Corporation to pass order, settling the tenements in favor of the petitioners by passing appropriate orders with it. My lord, and similar orders also passed in WPC number 1980.
When did you retire?
My lord.
When did you retire?
My lord, the appellant retired on 30/6/2022. 22.
কোথায় আছে?
ডেট চার্টটা দিয়েছি।
No, in this order that you are referring to, 28(3), which is at page 81.
My lord.
Was this petitioner a former employee or a serving employee?
Employees of the Bhubaneswar Municipal Corporation.
No. While they were in service or after they were
after retirement? Not only, my lord, 183. Another order is, my lord, I have obtained in lateral stage. 86 persons are occupant of their document, and by virtue of this honorable court's order, they are continuing in possession of their respective quarters.
Counsel for the appellant refers to an order dated 28 March 2019 passed by the single judge in WP Civil 19379 of 2010, where in respect of a former employee of the Bhubaneswar Municipal Corporation who was in occupation of a tenement allotted to him during his service, an order was passed for settling the said tenement in his favor post his retirement. According to him, the said order has attained finality and has in fact been followed in the case of more than 60 other
yes, madam,
similar former employees of the BMC. Paragraph. You say notice. Monthly accepts notice.
Other 90 people.
For 1 to 5 and 7. What is Union of India and all? I have put Union of India party.
My lord, I have made Union of India party since the first circular. Government of India instructed the state government to sell the.
No, there are no relief claim. You say since no relief is claimed against the Union of India,
I may be permitted to delete.
Respondents 8 and 9 would stand deleted from the array of parties.
My lord.
Notice to Bhubaneswar Municipal Corporation by registered speed post returnable on the next date. Based on 27 July.
Day of
there shall be the status quo shall be maintained till then.
From 55. 55, my lord, 30th August, my rehabilitation.
All right.
Item 56. 56, my pharmacist, my 20th July.
Right.
From 57. 15 old pension 25th September. I don't know, 58. 52 old pension 25th September. 59 similar matter, your lordship, 59 to 2nd August.
All right.
In one matter, your lordship.
Item number 60.
Let me see the last order on 28/3/2023.
Yes, Mr. Mishra.
Well, I've filed the affidavit, my lord. Yesterday I filed the affidavit master of com, my lord. What I found, my lord, the state government in its affidavit has not complied, neither complied your lordship's order, nor it has complied the report submitted by the NIH before the Supreme Court. Well, and also the Supreme Court has categorically stated on what aspect Honorable High Court should examine the issues. So that basing on that, your lordship had passed that order on.
Where is your affidavit? We have got a copy.
So my affidavit is not there. Already filed.
Copy maybe
My lord, what I humbly promoted, because there are a large number of persons. So my humble submission would be that all individual companies should also file affidavit, because their independent affidavits are also very much required. The first steps they have taken to implement the report and my lord, may I request them, all of them, to share their email IDs to my associate. He will send all the copies to them by mail. My lord, may kindly see. Last order, my lord.
All right. You see, the reply of opposite party number 5, bracket, National Institute of Occupational Health, bracket. Sworn to by Dr. S. Raghavan, scientist, capital D, working in the Regional Occupational Health Center, bracket Southern, Bangalore, has been filed and handed over in court today. Copies of the said affidavit be served on counsel for the other parties within 1 week. Paragraph. Mr. Manoj Mishra, learned senior counsel appearing for NIOH, points out that the state government does not appear to have implemented the report titled Environmental Health and Safety Issue in Coal-Fired Thermal Plants, framed by the Committee of Experts, submitted to the Central Electricity Authority, Ministry of Power, which is referred to by the Supreme Court of India in its order dated, in its judgment dated 31st February 2014. So he submits further that individual affidavits of the entities of the companies which are running coal-fired thermal power plants should also be called for to ascertain if they are adhering to the
guidelines as well as parameters.
Yeah, guidelines and parameters as suggested by the as laid down by the central laid down in the judgment of the Supreme Court, as well as in the aforementioned report. Paragraph. A direction is issued to the state of Odisha as well as the other individual respondents. Numbers, opposite party numbers. Three, 62. 60.
16.
Many of them are not represented here, or they are all there?
Sorry, madam.
Are many of them represented or not? These many respondents.
Opposite party number 5. NIOH is opposite.
No, not you, sir.
Oh, sorry.
Are lawyers appearing for all those companies arrayed as 6 to 61?
Yes, 61
Some
companies.
of them are, maybe some of them are missing out, I don't know, but many
to
of
file
them
their
are
individual
appearing.
affidavits before the next date. On both the above, on the above aspect. The longest date, 31st August.
31st?
August.
What I was just praying also, that let them share their email IDs so that I can, because I'll have to serve the counter also.
Yes.
I have already filed a counter to them.
Right. Copy of the affidavit that served on others, all other counsel through email, you see.
Through mail.
My lords, I have a small prayer, my lords. On behalf of OP number 6, I have filed IA 5537 of 2023. It is listed. During pendency of the writ petition, our company name has been changed from Tata Sponge Iron Limited to Tata Steel Long Products Limited. Let it be just corrected, my lord.
All right.
OP number 6. That IA is 5537. It is in the list, my lord.
5537 of
2023.
23.
Yes.
The reason stated the application is allowed. The amended, the consolidated cost it will be filed within a week. All right.
Oblige, my lords.
Diplo. Item number 61.
Your Lordship, in item number 60 for OP 19, I am on behalf of Nitish Kumar Mishra. Your Lordship.
61.
Collector Sundargarh.
Yes, my lords. Okay. Last order dated 1st of February 2023.
Reply was to be filed, Mr. Monty.
Yes, my lord.
By the collector Sundargarh.
My lord, that we have received a letter. He has requested for some time to file otherwise comment.
Last opportunity is granted to the collector Sundargarh to file a parawise reply to the petition on or before 1st July 2023. Rejoined thereto, if any, be filed for the next date. List on. First August. So that school item.
Yes.
62. You have to comply with that. You've done that.
Yes, I will.
So we'll take it about 2 p.m.
Which one? Oh, school item. 62. 62.
Hello, I have prepared the affidavit, but could not be filed. So I am giving that.
Mr. Ratha must be here, no? This side.
Mr. Ratha.
I am in the second matter. First matter, Mr. Professor says.
Show us what you've done.
Yes.
At least the both schools are done now.
Yes, ma'am. Given that the problem is that I could not file it in filing.
Then we need not, if you're filing it today, let Mr. Ratha go through it. Let's just see what you have filed. Very comprehensive.
62. Details of the all the proceeding with the development, everything. First matter. Details of the progress, your lordship can find it from para 7 of my affidavit.
Motion 6.
Dear Lords, you can find it para 8 that progress as on 2nd May, my lord.
Promise to complete it by 31st July. Was the both schools. All right. We say. Today, put your hands over. The 42-page affidavit. The commissioner comes in, it keeps the government school and mass education department, which contains 24 annexes running to over 100 pages.
66.
Setting out the steps taken, complying with the court's direction issue document with the W2020. The details of the funds sanctioned by the government of Odisha for repair and upgradation of schools, and the minutes of the meetings held for that purpose have been enclosed. Specific to the 7 elementary schools in the Bauch district, photographs have been enclosed of the progress of repair public upgradation of such schools. And the letter of the collector and district magistrate board, which appears to suggest that each of those 7 schools, the work in each of these 7 schools, the said 7 schools will be completed by 31st August 2023. Office orders concerning uploading of data relating to the schools in the UDISC plus portal. And transfer of assets of different departments to the Panchayat Raj institutions. Have also been enclosed. UDISC bracket, you say United District Information System for Education.
Item sir, how is it written as 103? Will not be there in the report.
Details of the resource allocation. in the school education sector have also been set out. It appears that nearly 150 crores in the budget for 2022-23 was earmarked towards repair and maintenance of primary, upper primary and high schools. And for both, approximately rupees 2.5 crores have been allocated. It is claimed that pursuant to the single courts high school transformation program, in the budget of 2023-24, rupees 80,514.50 lakh is stated to have been allocated towards the single courts more school abhyas, under which 10,000 schools will be targeted to be covered in the first phase. Okay. It is claimed that under the high school transformation program, 6,872 high schools have been transformed to modern learning centers in the last 3 years, and that the government aims to transform all the remaining high schools by the end of 2023. The details of the upgradation details of the Odisha Adarsh Vidyalaya Sangathan, bracket OAVS, have also been set out. The court has set out the above details in the affidavit.
But your lordship, I am sorry, my lord. In the previous orders, I'm sorry, my lord, I intervened.
No, tell us.
Previous orders, your lordship has been pleased to give the entire roadmap throughout the state, the school condition in throughout the state, primary schools, what is the condition? It's only sample 7 schools.
Correct.
Right.
So I'm not ending the matter. We're setting it out so that they should be
proactive.
bound down by
Yes,
all these
absolutely.
assurances.
Yes.
We'll keep it pending for monitoring.
Right.
Question. Yes.
I may be pardoned, my lord. I file a intervention petition, my lord. My lord, I file an intervention petition, my lord.
I think it's not. Is it on?
My lord, I
again speak to the mic, please.
My lord, I file an intervention petition only to realize some judgment of the Honorable High Court, and also act, my lord, that and a government circular regarding the parameter of appointment of teacher, Shikha Sahayaka teacher. The intervention petition may be allowed.
Let's see.
That's an issue. Your lordship has been pleased to observe that they will be taken care of on the latter part of the hearing of this matter. Your lordship are taking care of that.
Correct. The details of certain other schemes have also been set out. Full stop. Paragraph. It is stated that directions have been issued to all the district education officers. What is DPC? What does the DPC stand for?
These are all high schools.
All right, come DPC, so we'll see what happens. Physically verify the schools for a proper certification. As regards basic amenities, along with photographs. The court is setting out all the above details set out contained in the affidavit filed today, only so that continued monitoring of the compliance by the state government with the assurances held out in the affidavit is possible. Full stop. The court expects the different agencies involved in the task to strictly adhere to the timelines they've set for themselves, so that the objective of true transformation as promised is achieved. Paragraph. A copy of the affidavit is already available with the learned amicus curiae. Stop. It will be open to the learned amicus curiae.
Correct. I'll come back
to undertake, yes, visits to any of the districts of his choice to ascertain for himself whether the assurances held out in the affidavit are actually being seriously adhered to, and to file further reports in this court. So, since the proceedings by themselves are non-adversarial, it is needless to state that wherever the learned amicus curiae wishes to travel to inspect the schools, the local administration will extend their full cooperation.
Yes.
I beg to submit, my lord, the intervention petition.
We are not doing, we are still keeping it, sir.
Yes.
Not to worry at all.
Oh. Let's start taking care of those issues with
Yes.
Grateful. Let's fixing a date period sometime after vacation.
Second case is there, my lord. Two items are there. Second case, that is regarding that forged certificate. There I have to file an affidavit. That affidavit is ready, but that is incomplete affidavit, not in regard to the status of the investigation. Our last case, the lordship was directed to file an affidavit, the status of the investigation. But in that affidavit, which is ready now, my lord, that status of the investigation has not been reflected. So you'll also grant me 8 days time.
In that second matter, you say
there I may have a small little, of course, though I am not the amicus curiae there or concerned, but so far my knowledge goes, the allegations there in that matter that requires developing a complete database for the government, for the entire school, teachers having certificate, genuine, not genuine. They'll have to investigate that by a database throughout the state. It can't be done piecemeal, so that it will be a complete
not done. This is not in piecemeal throughout the state.
All right. You say, Mr. Kuntia states that some more time is required to file a proper affidavit disclosing the present status of the investigation. The affidavit possibly be filed on or before 17 July 2023. 24 July?
That will do.
24 July. listed.
But I'm sorry, I became little late.
No, no, no. It was supposed to be late 2 o'clock. So,
Great.
All right.
Item number 63. May I please, this is an PL matter, my lord. In this case, the opposite party constructed a chamber, water chamber in upper level of the Chetragota dam, my lord. And the petitioners, villagers deprived from the spring water. When they raised the objection and challenged that work order before this honorable court in previous writ application, this honorable court direct the collector to held a meeting and took a decision. Thereafter, they had a meeting and decided that under Annexure 1, the collector and other the local MPs, MLAs are there and decided to make a tank in a suitable place and supply the water in 2 villages equally. But during pendence of that resolution, that minutes of the meeting, they have constructed the work which has been issued under Annexure 2, work order issued under Annexure 2, my lord. And the present petitioners and their villagers deprived from the spring water, my lord, and suffer a lot.
Krishna village is which?
Talamaliga, my lord, under Kasipur block, district Raigada, my lord. Talamaliga.
Talamaliga gets water. That's what they've said.
The
see our previous order, sir.
Natural flow of the spring water blocked in upper level, and the water diverted to village of Amarsinguda. No water flowing to the village of Talamaliga, my lord, due to construction of that chamber, my lord. By
yes, filed a reply, sir.
Yes, by promulgating a 144 order under Annexure to what they have filed in last.
Just refer to the reply, sir.
10th February.
10th February reply.
My lord. Annexure 10th February 2023, my lord. My lord. They have. I have not filed any counter to this reply, my lord. I have rejoined, not filed.
Why?
I have already what they have mentioned in this reply. They have already mentioned same thing in their original counter, my lord.
No,
Nothing
come to para 14, sir.
My lord. That in reply to the averments in para 11 of the rejoinder affidavit, it is humbly submitted that the construction of spring box to supply water to Amarsinguda villagers has not blocked the original spring stream, and therefore the petitioner's village Talamaliga is not deprived of drinking water. Rather, only 1% is used for
0.001.
0.001% is used for Amarsinguda, and balance is flowing naturally as before the to Talamaliga. In summer season, there is a reduction in spring flow, and this is applicable equally to both villages.
So this is all disputed questions, sir. Now who is going to sit and they are saying that you are getting water now?
In fact, in summer season, no water is flowing to the village of due to blockage of.
They are disputing that, sir. They are disputing that.
During pendency of the writ application, they have constructed the alleged water chamber, madam. When the collectors and all the local political leaders resolved and decided that there will be construction of a separate tank and water will be supplied to both the villages. In spite of that resolution, they constructed the.
Sir, you have not filed any affidavit to dispute all of this. Why should we doubt this affidavit? It completely contradicts everything that you are saying.
One week.
No, it is specifically pleaded in our counter affidavit that para 10 may kindly be seen. In reply to the amendments made in para 7 of the way, it is humbly submitted that the just demand of Amarsinguda for potable water supply was directed by OSRC. Tolomaligura Grama was getting drinking water through 19 numbers of stand, post, and hence there was no such problematic issue for Tolomaligura village. We have denied what he has said.
Annexure 1 has not been complied. That is the only grievance before lordships. But decision the collector taken that has not been complied. That is the only grievance. That resolution under Annex 1 has not been complied. I will file the regent 1 week time or 2 weeks.
Going on endlessly, sir. I think there's no end to this. This has gone on for 7 years now.
Annex 1 is of the year 2015.
Yes.
And thereafter, many things have happened. Many developmental works.
Only the work order issued under Annex 2 that has been complied by promulgating under Section 144 of CRBC order in the locality. And when the petitioners village raised the objection to against that work order, they have promulgated the order under Section 144 and construct that chamber in the upper level of the spring water. And the Cherracotta spring is now declared as a tourist place, and no water is there, my lord. They have the government has invested much money in that project to declaring the Cherracotta Dam is a tourist place, but no water is flowing now to the Cherracotta water dam.
That is your
and the water has been blocked in upper level of that. In that whatever they have stated that has not been supported by any document regarding non-suitable of water in locality. No documents have been annexed.
So we have to stop this. They are all engineers, they're experts. Now we can't insist on documents for everything.
Only they have heard, but they have not filed any document. There is no.
But how can one go into this, sir?
My only grievance is what the under Annex 1, the collector take a decision to make a tank and provide water to both the villages. That has not been complied. And in spite of that resolution,
they repeatedly say that both villages are getting water.
Yes, that is our stand.
Their stand is only that, but in fact, no water is flowing to
the problem, sir. What you are saying is completely contradicted by them. It's becoming a disputed question of fact.
My lord, I will file the rejoinder to the reply of letter 10th to.
Theirs itself was a reply to your rejoinder. Now you want to file a reply to this. There's no end to it. It's your word against their word. It's become like that. All right. Say counsel for the petitioner disputes the averments in the affidavit of dated 10th February 2023. Filed by the Superintending Engineer, Rural Water Supply and Sanitation Division at Rayagada District, and states that he would like to file a further affidavit in response thereto. Affidavit of the petitioner be filed for the next date. 31st August.
Item 64.
Respondent number 5, 10, and 12 in this matter.
Item 64. There is no instruction. Your lordship may dispose of no instruction with a liberty if any.
So no instruction means no instruction. Counsel the petitioner states there are no instructions.
Liberty to revert back if any.
You have no instruction, where is it goes to liberty, sir? Contempt petition is also disposed of. All right.
We are appearing for the OP number 5.
And I think other opposite parties are there, but any attendance only for the purpose of this.
Okay.
I'm also
Obliged.
case for the respondent number 4 and 7. I'm the
Item number 65.
Item 65, my lord, I have no instruction.
All right, same order.
65, we have for opinion number 4.
All right.
Item
We are for
66.
number 1.
66. No instruction.
65, yes. 6 none appears.
66, I am appearing for the petition, Your Lordship. 66. Lordship, this is a public interest litigation with respect to the notice was issued, Your Lordship. They have to file the counter, Your Lordship.
Who has filed a reply?
Here, my
No
Lordship,
replies seem to have been filed.
Lordship, grant me 2 weeks time to file reply because your state has to also reply, my lord.
Nobody's filed, sir. Last opportunity to file replies within 8 weeks, rejoined up to the next date. September.
11. Item 67.
September.
Sure. 67.
Lord, in 67, my lord, I am appearing from the respondent, my lord. Last time, your lordship directed to take instruction whether the petitioner is prepared to withdraw the writ application, my lord. You know, the petitioner is not willing, and therefore your lordship may hear this matter on merit, my lord.
All right, Mr. Ashok Manthi, learned senior counsel appearing for the respondent states that respondent number 1 is not prepared to withdraw WP Civil 16810 of 2015 filed by. List on 11 September. Interim order to continue.
Item number 68.
68, I prefer a pass over minutes.
Item 69.
Your Lordship, I appear for the petitioner in this matter, Your Lordship.
Item 69, my lords. Mr. Rao has gone to a surgery, my lords, and he has requested to take this matter may have kindly taken after a vacation, my lords.
All right. It is stated that
Your Lordship, I do not have objection to the request, Your Lordship, but I would only request that in this case, since this matter has come, since this appeal is listed, there have been adjournments and adjournments throughout. That Your Lordship may take into consideration while giving a date in this matter, Your Lordship. Because otherwise the matter
that may be fixed. I have no words.
Mr. C. A. Rao, senior advocate, appearing on behalf of respondents 9 and 10, is stated to have undergone a surgery, and accordingly an adjournment is prayed for. Mr. Gadia, learned counsel appearing for the appellant, points to the numerous adjournments already granted in the matter. See list for hearing on. July, sir.
most obliged, Your Lordship. Most obliged.
Item number 70.
My lords. But the appellant has filed this application challenging the order of single judge, where the Honorable Court had referred the matter to before the Education Tribunal under Section 24B. Even though that part has already been adjusted by the petition of appellant. Lordship, I can see that last order. Last order, Lord. Also directed the director, because after considering my case, directed director to take steps against the principal who is not submitting all documents despite of the direction that is the this order. Last order, Lord. And in that, director also already issued a letter.
What's your President? You have not filed any affidavit, nothing.
We have filed an affidavit in shape of Lordship that was filed on already filed, my lord.
On 19th September 2022, my lord.
So they're saying that you have to approach the education tribunal.
Yes,
Yes, let me complete and I'll start. So that part has already been complied. Lordship, annexure 1. That part has already been complied with, so there is no necessity to go back again, Lord. Annexure 2, Lordship, annexure 2. This is a matter relating to approval and a grant of approval to the post of second post of Sanskrit and a grant of a block grant, Lord. But here, the petitioner, the appellant, pursuant to the advice annexure 1, Lord, was appointed as applied for the post of second post of Sanskrit, Lord. And along with another person also applied. Thereafter, since the procedure is wrong, the governing body, that is the quashed the selection. Thereafter, the subcourt interfered and gave appointment to the other person. That is why I preferred
it's against that
application
1611.
Lord.
Sorry?
Lord. Pardon, Lord. And they are learned tribunal, annexure 2. That I preferred before the education tribunal.
No, the impugned order refers to 24 capital B.
Yes, bro. Annexure 7, Lord.
Yes.
Yes, bro. Annexure 7, Lord. Yes. That is the letter.
So letter dated 7th April 2021.
7/4/2021.
Against that, you have a remedy under section 24 capital B.
That is not, Lord. Lordship, this is the letter issued by the Deputy Secretary Government to the principal to submit the documents only. To submit the documents. And the principal has a time and again submit all documents. Time and there and the last letter, Lord, personal Lordship direction, the director has already issued the.
Where is that 7th April letter?
Lord. That document.
Annexure 7.
Yeah, Annexure 7, Lord. Annexure 7, so that is the letter of the deputy director to the principal to submit all documents. After disposal of the case, your Lordship is already, they filed appeal for this FO. And FO also confirmed the order. Yes, Lord. Confirmed the order of tribunal.
Read that 7th April.
Lord. Right, Annexure 7, Lord.
Read Annexure 7, please.
Yes, Lord. That is letter issued by the Deputy Secretary to Government to the principal. That is the sanction of a block grant in favor of Srimati Surekha Das, lecture in Sanskrit, passport +3 wing as per the provision of the GI 929. I am directed to have to invite a reference to a letter number so dated 9/12/20 and number 20 dated 7/1/21 on the subject cited above, and to say that the proposal for sanction of a block grant in favor of Srimati Surekha Das, lecture in Sanskrit, passport +3 wing of the college could not be considered due to the following deficiency, and the claim is hereby rejected. The original these are documents, bro.
No, this is an order rejecting.
Yes, that I have challenged here.
This you can challenge under section 24 capital B of the State Education Tribunal Act. But that is what the single judge said.
But this rejection, Milord, that is with regard to non-submission of the documents.
Wherever. It may be for any number of reasons.
But yes.
But it is a rejection order.
But this is the documents on the learned tribunal already decided matter in my favor. Against that,
the appeal 2013, sir.
Yes.
We are now in 2021.
Yes, Lord.
Against this rejection order, you have a remedy under the Education Tribunal Act.
After this letter, Milord, the annexure 9, Milord. Annexure 9. Annexure 9 phase 55, Milord. The document is submitted by the principal. So there is no dispute at all. Lordship, may I read the annexure 9 phase 55. That is, Milord. That is the letter. That is to the Deputy Secretary to Government so. Request for reconsideration of a GI proposal, Dr. Surekha Das, lecture in Sanskrit, this one. With reference to the above mentioned subject and reference, I would like to request your good self for reconsideration of the GI proposal of Dr. Surekha Das, lecturer in Sanskrit, for release of a GI as per GI Order 29. As per the direction of the Honorable State Higher Education Tribunal in GI case number so and so and order 23/3/2013, the Honorable High Court of Orissa, FO number so and so. Judgment
letter.
Yes, these are
This is just a letter that you've written to them.
There is a complaint letter.
It's not a compliance, sir. You're asking them to reconsider. It's not a compliance. You're reinterpreting all these things to suit your own convenience. When I asked you about Annexure 7,
yes,
you said this is a letter calling for documents. It is not. It is actually a rejection letter. You are very conveniently reinterpreting, saying no. It is only a document.
But it is rejection. It is rejection on the ground that, despite of letter, the colleges of the principal did not submit the record.
Right.
That is the record. That Lordship can see that Annexure 2 is that is tribunal order. So what is the list, Lord? That has already been decided there. There is nothing is left now. Only this my client is still now is not getting that is salary, and now is board of retirement. Till today, Lord, he's not getting the GI, Lord. And that to that is dispute between the director and the principal. And Lordship has seen that. Lordship has the director letter. One letter I'll show that, Lord. That is sent to the AG office, Lord. But the two letters I'm saying that. What has been written there? The step of the director after rejection, what has been given there? That has been there. This is a letter issued by the director himself, Lord, to the president of the governing body. But I should the last paragraph I am reading that. Due to the principal's willful, due to the principal's willful and neglect.
Another cause of action.
Yes, but no, this is the arising of this, Lord. There is no causes, Lord. The arising of this by Lordship's direction. Lordship directed the director to issue contempt against the principal who is doing that. And the principal says, I have already deposited all documents. So there is no dispute at least still left, Lord. But only to linger the matter, my client is suffering, Lord. But let's say this is the doctor, the director himself is in this to take action on the principal. So here they are not submitting documents. So this is not dispute. So that's nothing is left for deciding, and my client is going to return, Lord. So if we will go there and again face the blood trial, what will be my client will be no here, Lord. My not getting the, so there is no dispute at all, Lord. So there is nothing is left there to decide it. So only document and college and this principal will submit all documents. And is that document also I have showed that document, what has been written there. That himself saying that. That is because we have submitted documents, its content should be issued. So nothing, my client is going to retire after 3-4 years, Lord, and is not getting any salary, Lord, in spite of which a qualified candidate that has been held by a lordship and that this Honorable High Court and also the tribunal. Because of their lacuna, I am suffering, Lord. So there is nothing. So there is no point to be decided. Then Lordship, I pray that Lordship may direct the principal to submit those documents which you are wanting by the director, Lord. And that is already submitted also. So otherwise my client will die in a habit. Nothing is there, Lord. After 4 years, she will retire, Lord. It will remit back to their letters. I will be nowhere by that time.
Challenge the present petition. Present appeal is to an order dated 16 November 2021, passed by the learned single judge. Disposing of writ petition civil 32832 of 2021 filed by the appellant. Challenging an order dated 7th April 2021, whereby the request of the principal of the Gopabandhu Science College, Attagad, Cuttack district, for sanction of a block grant in favor of the present appellant, who is a lecturer in Sanskrit in the said institution, was rejected by the Department of Higher Education, Government of Orissa. Paragraph. By the impugned order, the learned single judge has relegated the appellant to the remedy of an appeal under section 24 capital B. To the remedy not of an appeal, to the remedy under section 24 capital B of the Odisha Education Act 1969 and to approach the Orissa Education Tribunal to ventilate her grievance. Paragraph. Counsel to the appellant sought to contend that the said letter dated 7th April 2021 merely asked for certain documents to be provided by the institution. To stop, the court is unable to agree. The letter clearly states that, open quotation, the claim is hereby rejected, unquote. And is therefore conveying the decision of the Department of Higher Education. Paragraph. Counsel for the appellant sought to contend that all the documents necessary for sanction of the block grant had already been provided to the institution, to the department, and therefore relegating the appellant to the remedy before the SCT would only delay matters further. Paragraph. The court finds that reasons have been set out in the order dated 7th April 2021 rejecting the request of the institution for sanction of a block grant. Stop. Whether those reasons were justified or not will have to be examined in the first instance by the SCT. Stop. The court therefore is not prepared to permit the appellant to bypass the statutory remedy already available for the purpose. Paragraph. Finally, counsel for the appellant placed before the court copy of a letter dated 14 September 2022 sent by the Department of Higher Education to the president of the governing body of the institution in question. Setting out the discrepancies noticed in the proposal submitted by the principal of the institution. Stop. This letter again only sets out the various deficiencies noted and has asked for a reply, which ought to have been sent by now.
Yeah.
You sent a reply to this or not?
No, this is not to me, Lord. This is letter addressed to the president, governing body.
No. Have they sent a reply? You don't know.
No, that is not that is the AGP.
Counsel, the appellant is unable to inform the court whether any reply has been sent to the said notice. Stop. In any event, that would be a matter for the institution to pursue in accordance with law. The court is therefore not prepared to interfere with the impugned order of a single judge. The writ appeal is dismissed.
Let's face it. Within 3 months. But the
I don't know, 30.
Lakshmi died to complete the within 3 months. And the statute.
First, you go there. Let's.
But the statute notice may be wiped out. Otherwise,
all right.
Pastor matter item 38.
But time fixed. Otherwise, he is going to retire for 4 to 5 minutes.
38 minutes job contract 14th September.
14th September. All right.
Item 68.
68 minutes. I pray this matter to be taken up Monday minutes. Next week, any day minutes. And senior is held up. Who is leading this case is held up in another court minutes.
What's the matter about?
It's a case of dismissal minutes.
Counsel, the appellant stated in some difficulty. Let's go on. 18th September.
Lordship, I am appearing for the respondent bank. I may be pardoned for appearing through VC. My appearance may continue.
Yes.
Matters on special notice, writ appeal 910 of 2023.
May it please the Lordship. Would your lordships kindly turn to page 25? This was the advertisement, my lords. And if your lordships kindly see, my lords, the advertisement is dated 27th of March 2023. I'm sorry, 27th of January 2023. But this is a little important. 27th January 2023 was the advertisement. And the present writ petition, my lords, was filed on 25th of April 2023, almost 3 months thereafter.
4 months. Yes.
4 months thereafter. Now, kindly see, my lord, what has happened is the last date for applying was 18th of March 2023. So he didn't even apply by that time. Now, the fag end he comes, and if your lordship sees just the rules, my lords, the rules of OPTCL, your lordships will get at page 19. My lord, I'm sorry, my lord, would your lordship see page 27, and then we will go to the other page. Page 27 is age in the advertisement.
Must not be under 21 and
under
not
21 above 32.
As on 1st January.
Lordship pleases. Now, my lord, this is also in sync with our rules, and your lordships will see the rule, my lords, at page 19. Starts at 19, and the relevant page is, my lord, page 22.
So this enhancement doesn't automatically bind OPTCL, is it?
Lordship pleases. Lord, let us see the clause 3.11.2. The maximum age of entry into the corporation shall be 32 years, except otherwise expressly provided in the rules / orders regulating the method of recruitment to a particular post, provided that the maximum age limit can be relaxed as per. So it's a discretion of the board. It's not ipso facto. It doesn't automatically apply. Now, my lord, the difficulties are the following. My lord, A, kindly look at, my lord, my synopsis. And if your lordships kindly turn to synopsis B, paragraph D.
Numerous others who never...
if your lordship sees D, my lords.
D is for... Yeah.
D yes. For Delhi.
Yeah.
At page C of the synopsis.
Yes.
The recruitment process is conducted through a consultant so-and-so, the Government of India. The consultant has developed an online application based on the logic provided, and the link of that portal has been created. 4,282 candidates were issued with admit cards. This is all generated by the computer.
Right.
Were issued with admit card for the examination of the office grade so-and-so after satisfying the eligibility criteria. Now, my lord, what the learned judge, senior single judge says is, my lord, that you make a representation, decide in your board, but all this can't happen. There is no time. The order was passed on 1st and the exams are tomorrow, which means all these 4,282 candidates, if I change the date, my lords, the result is, which page is the, if your lordship sees page 15, my lords.
Correct. You say the present writ appeal by the Odisha Power Transmission Corporation Limited, bracket OPTCL, is directed against an order dated 1st May 2023, passed by the learned single judge, disposing of writ petition civil 13193 of 2023, filed by the respondent. Seeking the quashing of an advertisement dated 22nd January 2023, floated by OPTCL for recruitment of office assistant grade 3 trainee, on the ground that the upper age limit of 32 years, bracket, as on 1st January 2023, bracket, ought to be enhanced to 38 years, on par with the Odisha Civil Service, and on par with the similar age enhancement given to those applying for posts in the government in terms of a GA and PG department notification dated 11 January 2022. Under the Odisha Civil Service bracket fixation of upper age limit bracket rules 1989. Stop. By the impugned order, the learned single judge has, even while requiring OPTCL to consider the above issue in light of the GA department notification, directed it to accept the single quotes offline hard copy of the application to be submitted, unquote, by the respondent, and allow him to participate in the recruitment process with this result being subject to the decision to be taken by the board of the OPTCA. Paragraph. Mr. Parija points out that although the advertisement was issued on 27 January 2023, the respondent filed the writ petition only on 25th April 2023, that is more than 3 months thereafter, and literally waited till the last minute, since the exam is scheduled to be held tomorrow. That is 5th May. 6th May, is it?
Yeah, 5th and 6th.
Yeah. No, the exam is scheduled for 6th May.
5th and 6th, Malad.
Okay. Scheduled for 5th and 6th May 2023. Paragraph. Further, already 4,282 candidates have been issued the admit cards through online applications devised by a consultant based on by a consultant and allowing one candidate who does not satisfy the age criteria to sit for the exam would upset the entire schedule and cause enormous inconvenience. Full stop. Further, it is submitted that the rules governing that the recruitment policy of OPTCL does not mandate automatic adoption of the Odisha Civil Service bracket fixation of upper age limit bracket rules, and is in the discretion of the board of OPTCL whether or not it wants to adopt such enhanced age limit. Paragraph. The court is of the view that the appellant has made out a prima facie case of convenience in passing such orders also in its favor. Stop. Consequently, court directs that you say before that you say notice returnable. (21st June 2023) till the next date of hearing.
This was disposed of. There's an interim order. And your lordship may get that page 17 minutes.
All right. First January 2020, 1st May 2023. Passed by the learned single judge in IA number 16171 of 2023 in WP Civil 13370 of 2023, permitting the respondent to participate in the recruitment for the posts of assistant grade 3 trainee. The advertisement for which was issued on 27 January 2023. Full stop. Paragraph: the respondent who is above the maximum age limit as on 1st January 2023 of 32 years as of 1st January 2023 was seeking the quashing of the said advertisement. Full stop. Today, by a separate order in WA number 910 of 2023, this court has stayed a final order issued on the same date in another identical, passed by the learned single judge in another identical writ petition serial number 2334 of 2334 of 2023. Full stop. Notice returnable same date, 21st June, till the next date of hearing. The impugned order shall remain state. Order thus the. Right. Oh, right. After lunch.
order, my lord, from the court, my lord. But a recent development is that the petitioner in the meantime has died in the jail custody, my lord.
Oh, correct.
So, your lordship, I call for a report. That is my information. Some call from the sessions court as to whether 176 inquiry has been conducted or not.
Not this, that is beyond the scope, sir.
My lord, the report must come to the court, my lord. That is my non-official information. From the local advocate, your lordship, call from the sessions court, my lord.
No, which order called for the report?
My lordship, she order dated order 23/9/2022.
Read it.
Non-appears for the petitioner at the time of call. Two prisoners petition of the 2016. The petitioner found tagged in the record requesting the prompt hearing of the matter. This is by the petitioner in the prison. Hence, call for a report from the landed court in session of the case about the status of the petitioner in the custody or in bail.
So you are now saying that he has died?
Well, I got information. That is not concrete. Advocate has given me that information, but I have no concrete information. It's a man from Bombay. So let's make call for a report. So that
I will take instruction, man.
It was already adjourned, sir, last time. This was adjourned on 23rd September.
Yes, my lord. That was the order to the court of the sessions, my lord.
No. What happened to this call for a report?
Not yet issued from the.
All right. A reminder be sent to the court of the.
My information may be noted so that the report can be specific.
Which is the concerned court?
Designated
court. Special judge, additional sessions judge comes from Barampur. All right. From the court of the first additional sessions judge comes special judge Barampur, who sees the case. GR case or GE case?
GE case, my lord.
Your prayer clause says GR case.
Well, the GE, that is printing GR case, my lord. In the second line in bracket, that is shown as GR case.
GR case number 196 of 2014 about the current status of the petitioner. The registry will write immediately to the said court enclosing a copy of the previous order dated 23rd September 2022 as well as today's order. Paragraph. Counsel of the petitioner states that as per his information, the petitioner is expired. This will be confirmed by the concerned court.
In jail custody, my lord.
The roster bench on 28 June.
Jail custody, my lord.
Item number 2.
None appears dismissed.
Item number 3.
Same order.
Item number 4.
Same.
5. Item number 6.
May I please, Your Lordship? There is an application under section 457 of KRPC covered by Your Lordship's judgment also. That is Ashish Ranjan Mahanti versus State of Odisha. Release of ultrasound machine of a hospital.
You renew your application, sir.
That's it.
In view of the judgment of this court in Ashish Ranjan Mahanti versus State of Orissa, it's not reported, sir.
Reported, that's it. 2022 85 volume, OCR 700, page number 705.
It will be open to the petitioner to file a fresh application before the first additional session judge. Sorry, file a fresh application before the SDJM Pampur in criminal miss case number 278. So, just say SDJM Pampur Rourkela for release of the ultrasound machine, which will be considered irrespective of the earlier orders dated 9 January 2020 of the SDJM and 20 June 2020 of the first additional sessions judge Rourkela in criminal revision number 5 of 2020. The petition is disposed of in the above terms.
Item number 7.
May I please, Your Lordship? In this case, the petitioner challenged the order of cognizance that has been passed by the Lord JMC under Annex 2, my Lord. I have challenged the order of cognizance under 3 grounds, my Lord. If Your Lordship will kindly appreciate, my Lord, the order of cognizance has been of the alleged offences under section 406, 409 of IPC and section under section 7 capital A of the Essential Commodities Act, my Lord. Your Lordship kindly appreciate, my Lord. 7 capital A is not a penal offence, my Lord. So the Lord and Code JMFC, he has not applied his judicial mind. And with regard to the sections 406 and 409, Your Lordship can appreciate, my Lord, none of the ingredients, neither with regard to the, there is any entrustment and with regard to the dominion of the property by the present petitioner. And if Your Lordship will go through the FIR that is under Annex 9, my Lord, the petition name does not find in the FIR, not in any of the statements made by the witnesses. And with regard to section 7, kindly Your Lordship appreciate, my Lord, phase 14.
Nothing happens, sir. Even assuming 7A is not a penal provision, what is going to happen? Nothing is going to happen.
But that is the section 7 capital is not a penal offence. So
what will happen?
But he has not. But
so even if he says I'm taking cognizance, what can happen to you under 7A? Nothing can happen.
But the sole purpose here, the magistrate must apply his judicial mind.
That's all right.
But he has not applied his judicial mind.
Okay.
And in view of the, as Your Lordship knows, my Lord, in view of the Supreme Court guidelines as well as the by order passed.
What is, will your purpose be served? Suppose we remove only 7A. Will your purpose be served? It will not be served.
But with
you still have to face trial for 406, 409. You're okay with that?
406, 409 is also not there. If
suppose you're making so much of 7A. Suppose I say 7A is removed.
Exactly.
Will it serve your purpose?
As well as I have also taken the count that none of the
unless you succeed in 406, 409, the 7A is of no use to you.
If Your Lordship may kindly request the 7A at least, because 406, 409 is also not
7A is harmless for you, sir. It's not a penal provision.
But the magistrate
nothing can happen to you pursuant to 7A.
But before taking cognizance,
you're repeating the same thing and I'm repeating the same thing. So we're just going to say the same things again and again.
And if Your Lordship go through the entire materials, there is no ingredients of 406 and 409, my Lord. I am only the driver. And my name does not find place in the FIR, nor any of the statements.
All right. Permitting the petitioner to raise on this protestation. All right.
Item number 8. Item 8.
None appears dismissed.
Item number 9.
Same order.
Item number 10.
Item 10, I have challenged the criminal proceedings, my Lord. But I have only an innocuous trade to make. Your Lordship may direct the trial may be expedited, my Lord.
Yeah,
Since 2014,
permitting the petitioner to raise all pleas, including expediting the proceedings in the trial court. The petition is supposed to.
May I pray Your Lordship at least target the trial, my Lord? Since 2000, since last 1 decade, it's been there.
It's because of 482, things don't move. There is
no stay order, my Lord. There's no stay order.
But that's what happens. Your counterpart there will tell the court there's the 482. And the judge will keep quiet.
No proceeding due to pendency of this sum.
11th, same also.
Yeah.
Our appearance may be noted for the information.
All right.
Item number 12.
None appears dismissed.
Item 13.
Same order.
Item number 14.
Same order.
Item number 15.
Same order.
Item number 16.
Item number 15, may I please, your lordship. Item number 15. This case, my lord, I have paid for quashing of the FIR lodged against the present petitioner. In the meantime, what happened, your lordship, the principal accused has been acquitted by the Law and Trial Court. I'm filing the certified copy of the judgment, your lordship.
All right. You can point out to the trial court, sir.
Pardon, your lordship?
You can point out all this to the trial court. No problem.
Yes, sir. I will protect your lord.
Not necessary, sir. There are other provisions for that. Permitting the petitioner to resolve the proper stage.
Item number 16.
May please, your lordship. Challenging the entire criminal proceeding, allegation of offence is 498A 506. The present petitioner has never made to the OP2. She has earlier made it to another person. So my prayer is quash the entire criminal proceeding.
Permitting the petitioner to raise all pleas at the appropriate stage.
Yes.
Item number 17.
The memo is taken on record, not pressed. Dismissed is not pressed.
Item number 18.
None appeals dismissed.
Item number 19.
Same.
Item number 20.
Same order.
21.
May I please, your lordship? I am the informant, my lord. They filed the 482, my lord. That is under section, your lordship. That is 498A, 323, 307, and 294, 506, and 34 IPC, my lord, and 4 DPX, my lord. I am for the informant. They filed in this way. That is 3 cases also with pending, disposed of, my lord. So let it be dismissed, my lord. I am for the informant.
Yeah. It's all right. You're not for the petitioner.
No.
None appeals for the petitioner dismissed. All right.
Item number 22.
None appeals dismissed.
Item number 23.
23, my lord, on behalf of Mr. Dipali Mahapatra, my lord, that is challenging the FIR, my lord.
Permitting the petitioner to raise all pleas.
24.
May I please, your lordship? In item 24, the petition number 1 is the principal of a minority institution and the other petitioners are the member of the governing body. In the present application, the petitioners are challenging the impugned order of cognizance under page number 34, your lordship. Before I commence, my lordship, keep in mind at page number 34, serial number 3, Manveer Kaur is a lady. Now the order of cognizance is under page number 36, your lordship. Order dated 15th of October 2019. The cognizance has been taken under section 342, 294, 354A, 323, 506, and 34 of IPC. Now, Master, I'm challenging on the ground that, Master, may kindly see page number 17. Annexure 1.
Yes.
The complainant, who was working as a coordinator in the minority institution, she was suspended on 6th of April 2018, your lordship. Master, can you mark the date? I'm sorry, I should have prepared a list of dates. 6th of April 2018, your lordship.
She's not been served yet.
She's not, I've already noticed the issued, your lordship. Now she has changed her address. If your lordship will permit, I will take a fresh notice on correct address.
All right. The correct address of the opposite party number to be furnished to the registry within 2 weeks thereafter. Fresh notice returnable before the roster bench on 5th July.
I'm grateful, your lordship. Right. Can the LCR be called for, your lordship? Why I'm saying so? In the meantime,
let her be served first.
Yes, your lordship.
Item 25.
25, my lord, notice to opposite partner 5 on the correct address, my lord. Notice to opposite partner 5, my lord, she has left the place, my lord. I'll take
What's the matter about? Let us see.
Matter, my lord, here the complainant is the son of the opposite partner 2, my lord, through his first wife, my lord. The petitioner's first wife get a decree of divorce in the year 2008. Then in the next of occurrence, all of a sudden she has come while the open number 2 place will reside with the second wife, my lord. Here the petitioner, my lord. She taken away, my lord, 8 lakh rupees through mobile by mobile. That is annex page 15, my lord, of the application. Thereafter, I give bad message along with car, my lord, which is fine place as annex 3, my lord. I lodged a complaint, my lord. He has filed a bail application. After this application questioned against me. And my lord, the opposite partner 2 has already appeared and we be affidavit to drop this proceeding, my lord.
Permitting the petitioner to raise all pleas if the appropriate state. Petition is disposed.
My lord, that way your lordship may say that I have written a letter to the IAC, my lord. That is fine place at my lord. Annex 4, page 19.
Lord, charge sheet has been filed on 31/5.
Yeah. So permitting the petitioner to raise all pleas.
Item 26.
May I please, your lordship, permit to raise all the points.
All right.
Item number 27.
Nana, please dismiss.
28.
Say what?
Item number 29.
May I please, your lordships. Lords, I am on VC, your lordships. Lords, in this case, I have challenged the filing of
my lord.
1 minute, sir.
My lord, cognizance petitioner filed for the cognizance passing. But
whom are you for? Whom are you appearing for?
My lord, I'm petitioner, my lord.
Mr. Nanda, whom are you for?
I am for the petitioner, lords.
How can there be 2 people?
My lord, 7 petitioners in this case. Item 28, my lord.
28?
Yes, ma'am.
Okay. You just wait. Yes.
My lord, application under section 482, my lord, petitioners were filed for the cognizance passing, but in the meantime, they are acquitted in the court of the JMFC.
So, infractuous.
This is the
counsel with no need. Counsel with the petitioner states that the petition has been rendered infractuous. It is disposed of as such. All right.
29.
Yes, sir. Yes, Mr.
My lord. My lords, I have initially challenged the proceeding itself. But my lords, in the meantime, the police has conducted the investigation and returned the FIR as false on 21/5/2021.
All right.
Lords, and also a FIR was lost by the police because that he has used some false document as a genuine. And thereafter, my lords, he challenged also if a protest petition was also filed. And now ultimately the protest petition on merit by detailed order, the additional session judge Kujang has dismissed on 6/3/2023.
Anyway, so infractuous. Yeah. Mr. Nanda states that on account of subsequent developments, the present petition has been rendered infractuous. It is disposed of as such. All right.
Item number 30.
My lord, in this case, notice could not be issued to OP number 1 by the State Post with theory due to late filing of a requisite on 8562. Actually, notice filed in time, but due to Harvard clerk in suffering COVID, 21 days delay, my lord. So it was accepted and issue notice accordingly.
What's the matter about, sir?
Matter, my lord, OP number 2 already appeared.
138. Is there a settlement?
No, that is a 138 proceeding. Petitioner absolutely no way connected in this crime. Check issued in the name of OP number 2, but our learned magistrate confused and take cognizance. The learned court, honorable court already issued notice and stay further proceedings, but due to lapses of my advocate clerk, due to suffering from COVID, 29 days delay for filing of requisite, my lord. Requisite already filed, accept and issue notice. That is my prayer, my lord. My lord, kindly see the honorable court's order, my lord.
Yeah.
That is the order dated 8/3/2021, my lord.
No, that is different, sir. What is the order taking cognizance? 1 minute.
Today, my case was listed for acceptance of notice, my lord. Requisite, my lord. Not only other purpose.
It's all right.
Requisite already filed, my lord. Correct address already finished.
Yes. All right. The delay in filing the requisites is condoned. The requisites already filed, utilized for the fresh notice.
List.
Returnable before the roster bench on 3rd July. Yeah.
Item 31.
Nana, please dismissed.
32.
May I please your lordship
Permitting the petitioner to raise all this. All right.
Item 33.
None appeals dismissed.
Item 34.
None appeals dismissed.
Item number 35.
None appeals dismissed.
Item 36.
This matter has become infructuous.
All right. Dismissed as infractions.
Item number 37.
Memo taken on record. Not raised. Dismissed as infractions.
Item number 38.
None appeals dismissed.
Item number 39.
Same order.
Item number 40.
My lord, item number 40 not raised.
Dismissed is not raised.
Item 41.
Item 41, I pray your lordship just to one pass over your lordship.
All right.
All right.
Item 42.
My lord, 42 challenging the FIR, my lord, and praying for quashing of the shame. My lord, arising out of a civil dispute. The case of 2020, my lord. Might be charge sheet submitted.
Permitting the petitioner. Yeah.
My lord.
Item 43.
None appeals dismissed.
Item number 44.
Same order.
45.
Same order.
Item 46.
Same order.
Item 47.
Same order.
My lord,
48.
extremely sorry, your lordship. Item 41, I could not appear because of some network glitch, your lordship. May kindly 41, your lordship.
Yes.
My lord, item 41
Yes.
is a matter, your lordship, wherein there is only allegation under section 506 against the petitioner, who is a person of 72 years old. Now, the reason, your lordship, may kindly see annexure 1, though it is written in Odia language, but page 14, two dates, your lordship, I will bring to your lordship's knowledge. Page 14.
Yes.
My lord, your lordship, may kindly see two dates. After 4, 5 lines from top, your lordship will see 29/11/2020.
Yes.
It is written, my lord. Then in the bottom, your lordship, on the left side, it is written 4/12/2020.
This is about a fake caste certificate.
No, my lord. Allegation is that, but that is not a fact. The Tahsildar has submitted report in my favor. I have got a stay from the Honorable High Court. That is exactly the reason, your lordship. Page the top shows that on 29/11/2020, I threatened the brother of the informant. But informant lost the FIR on 4/12/2020 after a delay of 5 days, 506 allegation. Your lordship, the reason, my lord, may kindly see page annexure 2, page 17. Annexure 2, page 17, your lordship.
What is the court done, sir, that you're not saying? What did the SDJM do?
My lord, the FIR I have prayed for quashing of the FIR itself.
I know, but what did the court do?
The court has not done anything till date. The FIR
Then what are you coming here to the court for?
My lord, the history says I have submitted that after your lordship granted me stay on 2/12/2020, the informant lost the FIR on 5/12/2020, 4/12/2020, making an allegation that 29/11 I threatened his brother. And last,
Sir, has the court taken cognizance? What is this? What has the court
yes, your
done?
lordship. Today in the morning, I got information from them that the police has submitted final report in this case saying that it is a false case.
Then
But
that's the end of the matter.
But your lordship, that report I could not get.
It's all right. It's all right. It's all right.
I only pray for 1 week's time.
No need. We'll record his submission closets. Counsel for the petitioner states that he has informed that the police had filed a closure report. That view of the matter, the present petition has been intended infructuous. It is disposed of. Yes.
Item number 48.
45 matter infructuous, your lordship.
All right. 45 dismissed as infructuous.
48.
48 matter. It is a case of a bail jump. And the bail bond was accepted. 376 2 ml. So bail jump case matter. Yes, earlier lot of bail on bail, and due to COVID restriction, he was unable to come to Orissa when his avocation was a daily labor at Kerala, my lord.
Not 376, sir. Not in
So Belgium case, previously, was in bail, my lord.
376, sir.
Offense not earlier at bail, my lord, can page number.
For how many years are you now at large? For how many years are you now at large, sir?
COVID.
How many years now? When was NBW issued?
Kindly peruse.
Why don't you answer the question?
Page 6, my lord.
You first answer this question, then I'll look at any page. What is the date of the NBW?
Date of warrant, my lord, 22nd January 2019, man.
And now we are in 2023.
The recourse before this.
So 4 years, and the excuse of COVID, 4 years, rape accused is happily roaming around. Very good.
Due to court was
very good, very good. It's all right. The court finds absolutely. You want to withdraw it or we pass an order?
Let another chance be given under may surrender and face detailed expedition.
The NBW was issued in this case on 22nd January 2019 in an offense under section 376 IPC, where the petitioner, having enjoyed bail, failed to turn up. The court sees absolutely no merit in the present petition. It's dismissed as such.
49.
49, my lord, infructuous.
Dismissed as infructuous.
Or 50.
May I please? I am appearing for OP2. The matter has been compromised between us, my lord.
What's the offense, sir?
Offense, my lord.
Offense, my lord. 5 euro section 379, my lord.
All right.
And the counter,
opposite party number 2, lawyer for opposite party number 2, I mean counsel, tenders the affidavit of the opposite party number 2 stating that parties have settled their disputes and they have no objection to the prayer being allowed. In that way, the matter, take the prayer clause and all proceedings consequent thereto are hereby quashed.
51.
51 also same, my lord, counter case, my lord, that has been settled.
All right.
Same.
Item 52.
Hidden Nyundu.
52.
None of these.
Item number 53.
So item 53, liberty may given to raise all the points of the
committee the petition.
Item 54.
My lord, pray for withdraw.
Dismissed as withdraw.
Item 55.
55 rendered infructuous. Rendered infructuous.
Dismissed as infructuous.
Item 56.
None appears dismissed.
57.
Same order.
Item number 58.
May I please, my lord? The petitioner challenges the order dated 18/7/2008 at Annexure 2, my lords, thereby framing of charge on the ground of amicable settlement between the parties, my lords.
Yes,
my lord. I am appearing for the informant, my lord. That is settlement between the parties.
What is the offense, sir?
307 is there.
307.
It's all right. You say counsel for the opposite party number 2 states that the parties have settled their disputes and they do not wish to proceed with the criminal case. That we have the matter take from the prayer clause and all proceedings consequent that we haven't quashed. All right.
Machu.
Item 59.
None appears dismissed.
Item number 60.
My lord, 2 weeks time to be permitted to removal of defect.
What's the matter about? Cognizance order is more than 2 years old, sir.
Item 60, my lord.
Permitting the petitioner to raise all pleas at the appropriate stage. All right.
61.
None appears dismissed.
Item 62.
None appears dismissed.
Item 63.
62, my lord.
62.
62, item 62.
Yes.
Defects.
What is the matter?
Item challenging the cognizance order. And under Annexure 6, the defects are there 1 week. After one week may be given for the removal of defects.
Nothing, sir. Permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed. All right.
63.
My lord, it is a scheduled caste person, my lord. The caste certificate there, but it has not been investigated and reported by the police, my lord.
Which matter are you now in, sir?
My lord. Item 62, my lord.
62 is over, sir, now. 63.
Item 63.
63, my lord. I am challenging the order of cognizance taken by the London court below under Annexure 3, my lord.
Yes.
The offense is under section 420 of IPC, my lord.
Yes.
My lord, that of the case, my lord, is that one Bikram Kesari Jannamani had purchased one pair of shoes from Khadim showroom Bakshi Bazar Katak by memo number 81 of rupees 299. But the actual price was 229. The informant came to know that the price of the shoe was tampered using white color, and on cover of the shoes price was printed.
Charge sheet already filed.
Charge sheet, my lord, filed already. Nowhere my name was reflected, my lord. In any affair, my name was not disclosed. In 161, my name was not.
Okay, now you can raise this in the appropriate stage.
Already, my lord, raised, my lord. I am filed a 227 discharge petition, but that was subsequently rejected, my lord.
Then you can challenge that separately. Permitting the petitioner raise all pleas at the appropriate stage.
Item number 64.
Nana, please.
65.
65 towards wife had lost the affair before marriage. After registration of affair, marriage was taken place. Child was born. Now, husband is maintaining both wife and child.
Where is that, sir? Affidavit.
376 2N, my lord.
I know.
Yes, that was before marriage.
Or
now,
permitting the petitioner to raise all pleas. Correct.
Item number 66.
Lordship, item 66 on behalf of Mr. K. Manti, I am praying for an adjournment, your lordship. He is suffering from COVID, your lordship.
Counsel, the petitioner stated to be unwell, eligible for the roster on 28 June.
Grateful, your lordship.
Item 67.
Please, your lordship. The proceeding was initiated against the petitioner on the basis of the state scrutiny committee order. That state scrutiny committee order was challenging the read petition. Read petition, your lordship, is quashed and remanded back to the Dinamo inquiry. That's why the similar case, your lordship. The proceeding was quashed by the Russia 3 series, your lordship. Page 30, your lordship. In pursuance to the WPC number 14765/2009, and it was remanded back to the committee for de novo inquiry. And the criminal case is, my lord, is 17, your lordship, GR case number 244/2012.
Order dated 17/10/2012. In WP Civil 19052 of 2012. The case is disposed of in terms of an order dated 2nd August 2011 in WP Civil number 14765 of 2009, whereby the report of the state level scrutiny committee pertaining to the present petitioner was quashed. Consequently, the criminal case instituted on the basis of the said committee report cannot survive. That is the matter. GR case number
244/2012.
244/2012, pending the court of the JMFC G Udayagiri Kandamar, and all proceedings considered that hereby quashed.
68.
68, may I please, your lordship. My lord, I may be kindly permitted to conduct the case through VC, my lord. My lord, here, a young and unmarried girl is before your lordship, my lord. My lord, against the
my lord, opposite party who has been assassinating the character of the girl everywhere, every time, my lord, by filing cases, going before the media, publishing it in newspaper, everything, my lord. He is assassinating the character of the present petitioner, my lord. Your lordship will find. And secondly, my lord, the very same allegation, a complaint petition was filed under Annexure 2. If your lordship will kindly turn to Annexure 2, my lord. That is available at page 22, my lord. This arises out of a complaint petition which was forwarded by the learned magistrate under section 156(3), my lord. Which was, my lord, subsequently registered as an FIR. Investigation was conducted, and in the meantime, final report has been filed, my lord, stating that the allegations are all false, my lord. Now, on the very same allegation, another complaint petition has been filed. My lord, the first complaint petition is at page 30, your lordship will find. Exactly same allegation, my lord, without disclosing the earlier filing of the case, my lord, earlier complaint petition, and now the learned magistrate has issued process against the petitioner, and the allegations are very, my lord, your lordship will kindly have a glance. The allegations are very page 30. That this lady, this girl had earlier, my lord, relationship with the boy, and
No, but what are you challenging, sir?
I am challenging the
Process
issuance of
issue.
process in the case at Annexure 7. Exactly same verbatim paragraph, exactly same, my lord. Another complaint petition has been filed without disclosing that the earlier complaint petition was filed, and which was forwarded to the police. And now the magistrate has again issued process in that case, my lord. And the police has submitted final report stating the allegations are totally false.
So you say notice returnable before the roster bench on 5th July. Till the next date, further proceedings.
Let a copy
1
may be
CC number
sought.
4932/2022, pending the court of the SDGM Bhubaneswar shall remain state.
Let a copy may be served.
All that you should. Notice to the remaining. He accepts notice on behalf of opposite party number 1. Sorry, opposite party. You've not implemented the state, sir.
No, it arises out of a complaint petition. So, my lord, the state is not required to be made.
Not even pro forma.
Not, my lord. No,
all right.
Not necessary.
All right. And let's stop that. All right.
Urgent copy.
69.
My lord, 69 may be urgent for next week, my lord.
At the request of counsel petitioner.
Yes, under section 302, my lord. No CD also.
Why is it here before me? Why is a fresh bail application before me?
Out of 45 charge sheeted witness, 4 witnesses has already been.
May kindly see the rejection order, what it transpires from the rejection order that the trial has already commenced and 4 witnesses have been examined. And the informant
or disposed cases are below, it says. That was granted by me, is it? Hmm? Came here. All right. How many months? What's the period already spent in jail?
My lord, next week.
The informant to some extent has been examined.
Only
and
3 years.
Examination has been further deferred because of the non-identification of the material object, my lord, that is to be identified.
So the informant is still being examined?
Yes, my lord. He has been examined to some extent,
and his further examination has been deferred due to non-identification of the material object, my lord. It was not produced before the court. Therefore, at this stage, your lordship's consideration.
She's not the counsel. That's only.
Yes.
What is the reason for seeking adjournment?
Adjournment for at that four witness has already been examined. I have not given the certified copy of the deposition copy. That's why I want time for adjournment for next week, my lord.
No, but it's
for
hardly
better
3 years.
preparation.
The informant is still in the box. He says the examination is not complete.
Yes,
my lord.
So you renew it after the key witnesses have been examined.
My lord, after next week, I will be ready for the proceeding of the case and the hearing of the case.
What is the next date in the trial court?
No, that is not disclosed.
And CD is up to the CD is not comment.
Now the trial is going on, madam.
My lord.
No question of CD and all.
My lord, next week.
The request of counsel for the petitioner. List on 15th May.
Item number 70.
70 lordship permitted to withdraw.
Dismissed as withdrawn.
71.
None of this dismissed.
Item 72.
Lords, alleged offense on section 420, 468, 471, 506 by 34 IPC. Page 8 of the FIR, page 8 of the brief, the FIR, kindly see whether the FIR itself can trigger a criminal prosecution against the petitioner. Kindly see page 8, my lord. Purely a civil litigation, one paragraph FIR. I may be permitted to place it, my lord.
Yes.
My most humbly, I draw your kind attention regarding illegal sale deed, number so-and-so dated 4/6/2012, executed by Manoranjan Mahapatra, son of Gurucharan Mahapatra in respect of land, acre 0.180 decimal in Mauja so-and-so, plot number 132/1200, being duped under share of wheelie words in favor of Ranjit Mahanti and having hand in Tahsil Baripada, and by mutation and fraudulent maneuvers, he got the same mutated in mutation case 1268 of 2012 and got the record corrected in his favor without proper notice or physical verification. The Amin has also falsely reported that he is in possession of the same. Now he is giving threats and intimidation for evicting me from the property. Such action is fraudulent and illegal manner which needs proper inquiry, signatory so-and-so. But this she has conveniently suppressed. There is suit in 1987. She lost a suit, civil suit. Decree was passed in favor of my vendor. In an appeal, she succeeded, and second appeal is pending in this honorable court. All this civil litigation, she has conveniently suppressed. And if your lordship kindly see in Santilata Mahanti's case, lordship has been pleased to hold the same ratio.
No, but who is the informant here?
Lord,
informant is Santuna Mahanta.
But not made a party.
No, since a criminal, if based on FIR initiated by the police, she has not been.
It's all right.
It's not a complaint case. That's
No, it may not be.
Besides, my lord,
I can-
in this
I can-
case, charge sheet has already been submitted.
Charge sheet has been submitted.
Yes, ma'am.
Then you can urge all this, permitting the petitioner to urge all the pleas at the appropriate stage. The petition is disposed. There's no interim order here.
No interim.
All right.
Item 73.
73 permitted to withdraw your
Dismiss.
74.
No, please, your lordship. In the present petition, offense under section 493 and other allied offences, the matrimonial dispute, my lord. My lord, the father-in-law and mother-in-law who are more than 75 years old, my lord, they are come before your lordship. My lord, in the meanwhile, my lord, the husband has committed suicide after lodging of the affair by his wife, my lord. So his husband has already been died, and all the allegations, my lord, most probably against the husband, my lord. And your lordship, in this case, issued notice.
No instruction.
Permitting the petitioner to raise all pleas at the appropriate stage. All right.
But interim order to consent till that.
75.
Yes, my lord, charge sheet has been filed.
Charge sheet filed.
Yes,
That's what I thought.
Item 75.
Item 75. On behalf of Mr. Sambit Samant, this matter not praised.
Or dismissed.
Obliged.
Or
Item number 76.
Please, your lordship, I have passed an order for co-accused wherein the proceedings has already been quashed.
settled. No, is it the same case?
My lords, they are the co-accused here.
No, but what are the specific allegations? This is POXO, no?
Yes, my lords. In view of the settlement, the victim has now been married and he was the main accused. The case has already been quashed.
Lord, your lordship may kindly see order dated 18/11/21, my lord. Lord,
the main accused is already married.
Yes, my lords. And he is the petitioner in CRLMC number 1077 of 2021.
Oh.
That is Sudhir Biswaranjan Pratap.
The main accused has been quashed, sir.
18/11/21, your lordship may kindly see the order. The victim was directed to appear in person, my lord. At 376(2)(n), my lord.
My lords, nothing against the present petitioner. If your lordship may kindly have the glance to the
How
FI.
come it's only
It's section 6 of
main
Act.
petition is not getting? They've scanned out the main petition. Sir. LCR is alone coming up. Where is this affidavit of
My lords,
opposite party?
the affidavit has been filed by both the parties on the last occasion. They're on record, my lords.
Right.
On 2/8/21, the affidavit has been filed by the victim.
Para 2 of that affidavit, my lords.
All right. You say an affidavit has been filed by the opposite party number 2. Stating that she is already married to principal accused and is residing happily. And that the present petitioner is no way connected with her or is liable for commission of any offence. It is seen that by a separate order dated 24th August 2021, this court has already allowed CRLMC 1077 of 2021 filed by the main accused and has quashed the proceedings qua him in this very case. Paragraph. Consequently, while allowing this criminal MC, this court quashes criminal proceeding with a CT special POXO case number 15 of 2020 arising out of Denkanal Town PS 59 of 2000. Pending the court of the Judge Special Court POXO Denkanal, who are the present petitioner as well. All right.
Obliged, my lords.
Item 77.
Well, initially the OP number 2 before your lordship filed a 1cc case. Your lordship may kindly see the 1cc case I have given at page 11. The entire affirmance is, your lordship will see that the complainant will submit that he was absent from period 2008 to 15, and the said period he was in Visakhapatnam in daughter of Athara. So during period of absence, in good faith reposing confidence on accused number 2, handed over position of the accused to the accused number 2 to manage his business. Thereafter, accused number 1 gave to accused number 1 to manage the business. And entire allegations, if your lordship may kindly see, there is no iota of case being made out under 420 or SC/ST Act. Not a single word has been mentioned that there is a violation, there is a action regarding SC/ST Act. Now, your lordship may have a glance to Annexure 2 series, page 41. This present opposite party entered into was doing a business, entered into dissolution of business.
The for opposite party number 2?
Well, notice had gone, your lordship, on 18/12/2020.
No, somebody is appearing.
In the meantime, charge sheet has been submitted.
Well, charge sheet may be there, but if there is no case made out, why should
Not at this stage.
Your lordship, your lordship may kindly see one thing. To make out an SC/ST case, at least some uttering of the word should be there.
Let the court examine it. So that court can examine it. You see, now there's so much case law, you can cite it and you can get an order if you want.
Your Lordship may have a glance to kindly have a, your Lordship may pass any order.
Let the trial court
Your
appreciate all of this.
Your Lordship may have a glance to page 45. A novel idea has been given by the state that charge sheet is fine money, that is gospel truth. Whatever police says, that is gospel truth. That is not, sir, the gospel truth. Your Lordship, while sitting in court, has to also see whether such an offense is made out or not against me. Your Lordship may kindly see page 45.
All right.
At page 45, he writes to the Municipal Commissioner BMC that I have handed over the shop to him. My lord, where is the case of house trespassing comes? Where is the case of 420 comes? Where is the case of SC/ST comes, my lord?
Yes.
Nothing is there, my lord.
Yes.
All these things can be examined in 482 applications.
Correct.
This, what is this? This is a 482 application or not? This is not a criminal division. I am before your Lordship in 482.
Yes.
And that is,
and this is a 482 application. And 482, I have, if I prima facie show, my lord, that not a single word is there to prove SC/ST offense, my lord, then it's that offense at least has to go.
FIR was filed under the alleged offences. Subsequently, the charge sheet was filed under the said alleged offences.
Then what was the investigation, my lord?
The stage,
what was the investigation? If the same is replica, is a replica, the final form is the replica of the charge sheet, then there is no investigation, my lord.
Yes.
And if from the complaint petition, if my learned friend for the state can show a single line that SC/ST is made out, my lord, I will have nothing to argue before your lordship.
Yes.
Nothing is there, my lord.
Yes.
He himself writes to the commissioner that I have handed over the shop room. Now he files one CC case after coming back after 8 years, my lord.
Yes.
It is his own document.
All right. The court is informed that the charge sheet has already been filed in the matter. The court will therefore not like to get into the merits of the present petition at this stage, leaving it open to the petitioner to raise all appropriate pleas in the trial court at the appropriate stage. The petition is disposed.
Item number 78.
My lord, on behalf of Ms. Dipali Mahapatra.
Permitting the petitioner to raise all pleas at the appropriate stage.
My lord, I am
79.
My lord, this matter amicable settle in within party and she is appearing from the informant. My lord, I pray for, my lord, kindly taken up any other day next week, my lord, on that period of file affidavit of opposite, but no 2 and 3. She's appearing, but affidavit not.
SC/ST Act, all SC/ST Act can't be done like this. Permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed.
Item number 80.
None of this is disposed.
Item number 81.
May I please, your lordship? My lord, the petitioner is challenging the order of cognizance that is at Annex 3, running page 20, my lord. The petitioner by then was working as the additional divisional railway engineer. He issued the notice that is under Annex 4 series, my lord, running page 21. On 11/11/2021, the petitioner issued a notice to the husband of the informant to vacate the house, as because he was transferred to other place, my lord, and that quarter was allotted to some other person. Again, reminder was issued on 28/11/2011, my lord. On 13/12/2011, my lord, the informant alleged that the present petitioner tried to enter inside the house and tried to forcefully disconnect the electric connect. On this allegation, the FIR was lodged and investigation was completed. Charge sheet submitted, my lord. Without sanction, the London magistrate has taken cognizance, my lord.
Okay, all that you can urge at the appropriate stage.
After cognizance, the petition came before your lordship, my lord, and interim order is there also.
All right. Permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed of, the interim order is vacated.
Item 82.
To my lord, and to my lord, in this application, the petitioner pays for quashing of criminal proceeding, my lord, on the ground of settlement, my lord. The informant doesn't want to proceed with this case and she has filed this affidavit, my lord.
Yes, my lord. And appearing for the informant, my lord. Informant already married, my lord. No proceed with the case, my lord.
All right. The affidavit of the informant is affirmed, states that the parties have settled their disputes. And she's already married and leading a happy life. Counsel appearing on her behalf confirms this. That is the matter. All proceedings consequent that were questioned. All right.
Item 83.
My lord, item 83 on behalf of Mr. S.D. Das, my lord, may I prefer any other day? He has some personal inconvenience, my lord. Any other day, your lordship. There is an interim order, my lord, also.
That's the whole thing, sir.
My lord.
What is the matter about?
My lord, here the officers of ArcelorMittal Nippon Steel are before your lordship challenging a FIR which has been lodged against them for a demonstration. This is a counter FIR which has been lodged because they were hurling stones and all that. Local people were hurling stones on the officials of the company and the vehicles. A FIR was lodged first by them. Pursuant to that, counter FIR was lodged. My lord, here in the meantime, there has been some development which my lord, Mr. Das will apprise your lordship.
All right. At the request of Mr. C. Das and the senior counsel appearing for the petitioner, let's look for the roster bench on 12 July. Interim order to continue.
Obliged.
Item 84.
May I please, my lord? Right, the petitioner before your lordship is a bank, which is one of the third largest private sector banks of the country, my lord. My lord, for the purpose of doing business, my lord, only for the purpose of reposition, the petitioner bank is required to have a trade certificate under the provisions of the Motor Vehicles Act, read with the Central Motor Vehicle Rules, my lord. My lord, prior to 2020, as per the requirements of the Transport Department, your lordship would see under Annexure 3 at page 24. My lord, one trade certificate was required for one class of vehicles, and thereafter, my lord, your lordship, just kindly turn to Annexure 3 at page 24. Clause 2, my lord. My lord, the financier will obtain trade certificate for minimum 10 vehicles for each class on payment of requisite fees prescribed under the Central Motor Vehicle Rules. Onus lies on the financier to submit report annually about the total number of vehicles financed during the year within the 15th of April every year to the concerned registering authority and to pay the balance fee to the registering authority, my lord. But this practice continued till 2020. But in the year 2020, for the first time, the Transport Department introduced a system of online registration where registration was supposed to be done from the dealer's point and the trade certificate was required, but only with a modification. Your lordship may kindly see.
What happened in the investigation, sir?
But no harm has been caused, well, clearly hit by section 95 of the Indian Penal Code. But it's nothing has, no loss has been caused.
No, what has happened?
Yes, my lord, the charge sheet has not been submitted, my lord.
Oh.
And your lordship would see it's so trivial in nature.
Investigation be apprised to the court on the next date, interim order to continue.
Yes, my lord.
Let's before the roster bench on 24 July.
Grateful, my lord.
Item 85.
I may please your lordship. My lord, the petitioner filed this application challenging the initiation of the proceeding. Initiate under section 12 of the Protection of Women from Domestic Violence Act. The petitioner is the daughter-in-law and the opposite complainant is the mother-in-law. The ground of the challenge is that the complainant is not coming under the definition of aggrieved person as defined under section 2A of the DV Act, which has been quoted at paragraph F, page 5, my lord.
My lord, I am appearing for the OP number 2, my lord. In this case, my lord, witnesses have already been examined before the learned court below, and final order is awaiting, my lord.
Then no need to inform.
There is a stay order. How
opposite party number 2,
my lord,
informs the court that witnesses have already been examined in CMC number 49 of 2019. So CMC 49.
Yes, ma'am.
My lord, 49 of 2019.
If the court of the SDGM Titlagar and stage of and the case is at the stage of final arguments. Paragraph. In that view of the matter, the court is not inclined to interfere. The petition is dismissed.
Item 86.
Obliged.
Well, item number 86 is permitted to withdraw, your lordship.
Dismiss, just withdraw.
87.
Please, Your Lordship. Milord, I'm on BC.
Yes.
Milord, so a money claim, simple money claim, which has been made before the resolution professional in an NCLT proceeding, has been filed before the IO and IO has registered FIR. That's my only case to pass the FIR, my lord. Also, kindly see Annexure 2, page 26. The resolution professional in NCLT proceeding invited claims, public claims. Under Annexure 3, opposite part number 1 submitted his claim, 22 lakh something. Then that is proceeding is pending. In the meanwhile, he has filed the FIR that for the same amount, that this amount has not been paid. So the authorities of Ortel have cheated me. And this registered FIR has been registered. Kindly see the confirmation.
Who's for the other side?
I am appearing for in the second case, my lord.
Second case is anticipatory bail.
My lord.
Second case meaning?
There is a case, the other case is attached, bail application is attached, so I am appearing for even the bail application.
For whom?
For the info. For the petitioner, my lord.
For the petitioner. Okay. Same petitioner. Who's appearing for the opposite side?
Same petitioner.
Lord, one Manas Ranjan Badajana is appearing along with his
All right.
associates. my lord.
Mr. Manas Ranjan Badajana, advocate who's entered appearance on behalf of the respondent is not present today. The registry will telephonically inform him to remain present for the next date. Interim order to continue. Let's go for the roster bench on 19 July.
Oblique.
Item 88.
My lord, may I please your lordship? My lord, the petitioner before your lordship is the uncle-in-law of the informant. My lord, in 498 case, the uncle-in-law who's having a separate residence have been arraigned. My lord, I am just referring to a judgment of the apex court, only 3 lines, my lord. Para 18 of this judgment, 2022 judgment, my lord. Coming to the, my lord, got it?
Yes.
Para 18. Coming to the facts of this case, upon a perusal of the contents of the FIR dated such and such, it is revealed that general allegations are leveled against the appellants. The complainant alleged that all accused harassed her mentally and threatened her of terminating her pregnancy. Furthermore, no specific and distinct allegations have been made against either of the appellants herein of the general allegations made against them. This simply leads to a situation wherein one fails to ascertain the role played by each accused in furtherance of the... What has happened?
Informant.
My lord.
I'm
my lord. Only a line.
1 minute.
I'm sorry.
What do you say?
There is a prima facie case, my lord. All the witnesses stated against the petitioner, my lord.
Which witnesses?
All the witnesses, my lord.
Trial is already going on.
No, my lord. Charge sheet submitted, my lord. Cognizance taken.
How do you call the witnesses right away, sir?
The statement, my lord. One statement.
That's all.
My lord, one line I'll read from the FIR.
Yes, my lord. Charge sheet
one line from the FIR. My lord, one line from the FIR. What is against me? Only that. This I submit to your lordship, may pass that order. I'll just for your own, for my own satisfaction, my lord. That after resigning the job reluctantly, I stayed at Bhubaneswar in my in-laws' house. My in-laws, namely mother-in-law, Saleha Begum, brother-in-law, uncle-in-law, Said Anwar Ali, and husband Muhammad Allah and other in-laws tortured me physically. The entire allegation is this against me.
Permitting the petitioner raise, now that the charge sheet has been filed, the court permits the petitioner to raise all pleas at the appropriate stage in the trial court. Petition is discussed. All right. Interim order. There's no interim order.
There was an interim order.
Interim order is vacated. All right.
Obliged.
Item 89.
None appears dismissed.
Item number 90.
May I please, my lord? My lord, challenging the crossing of proceeding, my lord. Case and counter case, my lord. In the meantime, amicable settle between the both the parties, my lord.
My lord, I am appearing for informant, my lord. Matter is settled between both the parties, my lord.
All right.
I submit affidavit filed by informant.
All
right. There is a connecting case, my lord. This case.
The affidavit of the respondent number 2, opposite party number 2, has been handed over in court by his counsel. It states that the parties have settled their disputes and that he does not wish to pursue the criminal case against the present petitioner any longer. petitioners any longer. In that view, the matter taken in the prayer clause and all proceedings consent to that hereby quashed.
Your Lordship, may I make a mention?
1 minute.
Pardon, my lord. My lord, item number 59, my lord. My lord, the quarrel between the mother and son, my lord. My lord, if this matter is good, the mediation center, my lord, it will settle, my lord. Mother and son, my lord.
Which item number, sir?
59, my lord. Four, 6, 7 of 2023, my lord.
Where is the affidavit?
My lord. My lord, item number 59, my lord. My lord, this quarrel between the mother and son, my lord. Mother filed the affair, my lord, against the son, my lord.
Right.
My lord.
Where is this? Where is the settlement?
My lord,
there is a settlement.
My lord, if this matter is go to the mediation center, my lord.
No, nobody is there for the other side, sir.
My lord, notice.
No.
My lord, this is the mother and son, my lord.
It's all right. What's the offense under?
My lord, offense under section.
Only my lord. An affidavit, sir, it's not possible. Permitting the petitioner to raise all pleas at the appropriate stage. The petition is dismissed. Right.
Your Lordships, yes, this is a writ appeal matter, Your Lordships. It had come up on 25th.
Why did you mention it when the other side is here?
No, Your Lordships, it's a fresh admission matter. Of course, it's a state, but it was not heard. It was a fresh admission matter.
I'm sitting singly. Tomorrow morning, mention it.
Lordships.
No problem.
Item 9 is a connecting matter. CLMC 3832/17 that has not listed. The matter was quashed today. Item 90, my lord. Item 90, the OP number open 2 there is the petition in the another case CLMC 3832/17, my lord.
What is listed today?
So that has not been listed, my lord. So the connecting matter. This one that matter has not been listed, but this matter has been quashed. So I pray this matter may be listed along with this case, my lord. CLMC 3832/17. The other case is, my lord, they are filed CLMC 180020, that is item 90, my lord. Both matter has been compromised, but that matter is quashed today. But my matter has not been listed.
How did we take it on board? Taken on board. What is that? Criminal C number?
Criminal miscase 3832/17.
3832 of 2017. But all the numbers will change, no?
Yes, today was listed 180020.
No. In that matter, sir, the other matter,
yes, ma'am.
The PS case numbers and all will be different.
Is PS case number other matter is PS case 135/17.
Tomorrow, I think. Tomorrow. We'll list it tomorrow. We'll take those number, list it tomorrow. All right. Yes.